you all for being here. We're going to start our afternoon session for this symposium. I first want to offer my thanks to the Kentucky Journal of Equine Agriculture and Natural Resources Law, which we affectionately refer to as K-Journal around the law school. They have nicely offered to sponsor this program. The first part of it involved equine law this morning, and this afternoon we're going to be talking mostly about natural resources and agricultural law. We may talk a little bit about environmental law as well. The K-Journal has been at the law school for the past decade or so. It actually began earlier in 1984 as the Journal of Mineral Law and Policy, and at this point it looks at a wider range of material. It's published twice annually by the College of Law. And what we're going to do today is, thanks to the work of principally of Dylan Nichols, who put together this symposium, we're going to talk about whether regulation is something that tends to improve or impede the use of our natural resources and the development of agriculture. And we've got a number of outstanding speakers here to talk about this issue. We can see it sort of played out significantly in public policy issues today, where our political leaders have the obligation to consider how to balance economic growth against the protection of human health and the environment. I think one of the most prominent places where we can see that played out currently is on the whole question of climate change and our ability to move away from a carbon-based economy. And maybe that issue can come up as we talk through the afternoon. I wanted to first introduce the speakers, and then they'll come up and talk in turn. Our first speaker is going to be Tom Fitzgerald, who's the director of the Kentucky Resources Council, which is Kentucky's only environmental advocacy organization that offers legal and strategic assistance without charging individuals, community groups, and local governments across the state. Tom previously served as a staff attorney at the Appalachian Research and Defense Fund of Kentucky. He received his BA from Roger Williams College and his JD from the University of Kentucky College of Law. Tom received the 14th Heinz Award in the area of the environment a few years ago. The Heinz Foundation, in explaining that award, said that, quote, Tom Fitzgerald has been a ubiquitous leader in advocating for the fair and equitable application of environmental laws, and has tirelessly shouldered the causes of those without the resources or expertise to fend for themselves. He is singularly responsible for the health and well-being of countless individuals, thanks in large measure to his vigilant commitment to seeing that environmental protections are enforced and the welfare of our citizens regarded as sacrosanct. He has recently accepted a presidential nomination to serve on ORSANCO, which is the commission that establishes water quality standards for the Ohio River. Our next speaker will be Herb Miller. Herb is the current president of Columbia Gas of Kentucky, a natural gas distribution company that serves 130,000 customers in 30 counties in Kentucky. He's had that position since 2006. Prior to that, he served as general counsel for Kentucky American Water Company and was a partner with Stoll, Keenan, Ogden in Lexington. Mr. Miller received his BA in History and Political Science, along with his JD from the University of Kentucky. Then we have Professor Jim Huffman. He's Dean Emeritus at the Lewis and Clark Law School in Portland, Oregon. For those of you who don't know Lewis and Clark, it's a school that's very well known for its focus on environmental law and natural resources law. He's been teaching there since 1973. Previously, he graduated from Montana State University, the Fletcher School of Law and Diplomacy at Tufts University, and the University of Chicago Law School. Among other memberships, he's a member and former chair of the Executive Committee of the Environment and Property Rights Practice Group of the Federalist Society. Dean Huffman has been very involved in issues related to public lands and national forest management. Our next speaker will be Baylen Linnekin. Baylen Linnekin is the founder and executive director of Keep Food Legal Foundation, a 501c3 nonprofit that promotes Food freedom, that is the right of every American to grow, raise, produce, buy, sell, share, cook, eat, and drink the foods of their own choosing. He serves as an adjunct professor of law at George Mason University Law School and an adjunct professor in anthropology at American University. He received his BA and JD degrees from American University, and he has an LLM in agriculture and food law from the University of Arkansas School of Law. And then our final speaker will be Professor Alan Olson. Mr. Olson Mr. Olson practices in the area of agriculture in Albany, Georgia. He received his BA from Cornell, his JD from UNC, and an LLM in agricultural law from Arkansas. He teaches in the LLM program in agriculture and food law at the University of Arkansas School of Law in the areas of federal farm programs, crop insurance, and future issues of global food security. What we're going to do is the speakers will come up here. They'll speak for about 20 minutes or so, and then we'll have an opportunity to ask questions and discuss their comments after each speaker. And then if we have any time at the end, we can have more of an across-the-board discussion. Tom Fitzgerald is going to speak first. He will have to leave after his presentation to go to Frankfurt to deal with legislative issues. So, Tom.
As an extinguished alumnus of the UK Law School, it's always good to be back here. I'm going to very briefly cover some coal issues, and then if there's questions that you all have, I do apologize, I'm going to have to leave a bill that I've been trying to stop the legislature from adopting for the past 4 years, commonly known as the AT&T bill, is going to the House floor for a vote today, and I need to be there to see whether we're going to be successful in stopping the bill or at least amending it so that it's less dangerous for the public. Let me start, as I always do, with full disclosure, so you can completely discount everything I say from here forward. I work with the Kentucky Resources Council, as the Professor mentioned. I used to be an attorney with Applegrant. Actually, it was over at Max Welcome Court there at the rickety house that's on the bend there, doing environmental work from 80 to 84. I was actually a law student there and do work study from 78 to 80. The Resources Council used to be the Kentucky Rivers Coalition. They fought all the big dam projects, or the damn big projects, depending on your perspective, that the Corps of Engineers was trying to build, including impounding the Red River Gorge, which is now a National Wild and Scenic River. I came to them in '84 to set up kind of a legal aid model of environmental assistance. We don't charge for what we do. We don't take fee-generating cases. We don't take corporate or government money. So it's completely unsustainable. It has been for 31 years. But it gives me a unique perspective, some might say a bias towards environmental issues and energy production issues. I cut my teeth working on the 1977 Surface Mining Act, which was the last comprehensive piece of legislation other than the 1990 Clean Air Act amendments affecting the coal industry, rather than affecting a media like air, Clean Air Act, Clean Water Act, Underground Safe Drinking Water Act. It actually regulated an industry from the beginning of the breaking ground for coal exploration to, theoretically, the accomplishment of a post-mining beneficial land use. And what's really been remarkable, while the rhetoric was hot and heavy during the last couple of electoral cycles, here in Lexington in particular, with the congressional election and then the senatorial race about the so-called war on coal, what's really been, from a kind of a systems view or a little bit of a distance view, you see that the history of coal over the last 30 years has really been one of the effect of regulation in internalizing costs that are associated with the production, the movement, the conversion, and the disposal of waste related to coal. Every energy source has its footprint, whether it be wind, hydro, natural gas, nuclear, coal. Coal's footprint tends to be heavier than most. And what has happened over the years is that systematically, starting with the 77 Clean Air Act amendments, but then really in 1990, which was the bipartisan Clean Air Act amendments that were signed into law by George Herbert Walker Bush. It really was the last real bipartisan piece of environmental legislation, other than maybe trying to build the Keystone Pipeline. The Clean Air Act amendments really started a process of internalizing pollution costs associated with the combustion of coal in power plants. You know, you grind the coal into pulverize it, you inject it into a flame in order to boil water to turn turbines to make electricity. And there are a lot of byproducts that occur from that process, none the least of which are emissions of various particulates, sulfur dioxide, nitrogen oxide. So what you've really seen, and what is a particular challenge to Kentucky, is that we have built a large part of our manufacturing economy on access to artificially cheap electricity. Right? We have a third of the aluminum, a third of the stainless steel, and a fifth of the cars and trucks of the nation being built here in Kentucky. And they're not here because they like the climate, although I find it preferable to Boston this time of year. But they're here because of the access to transportation and largely because of coal-fired power. And the great challenge for the Commonwealth and the struggle for many communities at the local level is how to adjust to the changing economics and the changing regulatory structure that is now making the generation of electricity more costly at the production side, and particularly for ratepayers. And since we work at the intersection of poverty and environmental pollution, a lot of the clients that I represent are particularly hard hit by increases in their electricity rates. So it really is a somewhat of a daunting challenge for the state. We saw initially controls on particulates. We saw in the first phase of the 1990 Clean Air Act the efforts to control sulfur dioxide, so-called acid rain provisions, because back in the earlier days, you were able to build taller smokestacks and export your sulfur dioxide pollution, because we were measuring pollution at ground level. So it was not too long before you started seeing the long-range transportation of these pollutants having impacts on agriculture, acidification of lakes in the Northeast, and so in 1990, Congress acted. What happened in Kentucky as a result of that is that the production switched from the western Kentucky coal fields, the so-called Illinois Basin, which is higher sulfur coal, to the Appalachian coal fields in eastern Kentucky, in large part because you could meet the sulfur restrictions just by burning what was called compliance coal. So you saw a boom in the east, a corresponding flat line in the west in terms of production. With the second phase of the Clean Air Act amendments coming into effect in terms of sulfur dioxide, it was a reverse, and we are now seeing that reversal. What happened is everyone who is going to continue to burn coal is now scrubbing their emissions. Once you put the scrubbers on, there's no reason why you would buy more expensive Appalachian coal when you can burn anything that is high sulfur. And so you're seeing an increase in production in western Kentucky, particularly western Kentucky underground coal, and the western United States, the Powder River Basin. And you're seeing a precipitous decline in the production in the Appalachian coal fields of eastern Kentucky and West Virginia. Now, there's still a significant amount of production. There are metallurgical grade coals that are being produced, but the steam market, which is 95% of where Kentucky's coal production goes, is to make steam to turn turbines, has really been in decline and will continue to do so. The second driver has been the resource availability. The easy reserves, the moderately hard reserves to produce, have all been produced. And what's left, other than a big block of coal under the Robinson Forest, which I periodically have to fight the university over trying to mine, in which I keep having to remind them they were one of the co-petitioners with us back in the early 80s in trying to stop mining the forest. But other than that block of coal, there's not a lot of big coal left in eastern Kentucky. What's happened is, even without any other drivers, if you looked at the Energy Information Administration, which is a really good source of information, they're better at predicting the past than the future, but so are we all. But they do have some trend analysis, and one of the trends is that the availability of Appalachian reserves was precipitously declining right around now. Add an additional driver, which is not directly regulatory in nature, which is the shale gas revolution. The marriage, some would say an unholy marriage, of hydrofracking using high volumes and high pressure of water to induce fractures in tight shale formations. The Bakken Shale in the west for production of oil, the Marcellus and the underlying Utica in Ohio, West Virginia, Pennsylvania, in order to produce natural gas in the east, with horizontal drilling, which allows you actually to turn the wellbore and go into the the production zone, or the play as they call it, has really been a game changer, not only domestically but internationally. Can anyone remember the last time we had this kind of unrest in the Middle East and we saw gas prices at $2.29 a gallon, or actually we drive for sales $2.16. So it really has been remarkable, but it's also caused a great destabilizing in the coal fields, particularly in the Appalachian coal fields, because what has happened is, as everyone is having to make a decision for our existing fleet of power plants on whether to retrofit or to go with a natural gas-fired plant. Heretofore, natural gas was used for peaking. These were units that you turned on just when you needed to because they responded quickly, but they were more expensive because gas is more volatile, it was more, no pun intended, it was more expensive. You'd only use them to meet the really hot summer or the really cold winter days. Now we're talking about base load natural gas-fired plants, which are more efficient and which are less expensive to run when you run the projections, because natural gas is at record lows because of the volumes of gas that are being produced in the Marcellus and the Utica fields. So it is a real challenge for the economy of this state, which has wedded itself to an abject dependence, reliance at one point, but now it's become a kind of an uncomfortable dependence on coal-fired power, which is seeing the cost go up. You're already seeing some of the major manufacturers kind of pushing back against this. There was a big row in Western Kentucky as a couple of the smelters, which use a tremendous amount of electricity, were threatening to leave unless they could buy market power, natural gas fired, and bypass their local utility. That, of course, shifts the costs that were incurred to build that power plant on the assumption that these customers would be there onto the remaining customer base, which in many cases can ill afford those impacts. Our biggest challenge lies in front of us, and that is, how do we deal with climate change? The new rules for the existing power plants under Section 111D of the Clean Air Act require that they address carbon and lower the carbon footprint of coal-fired generation electricity. The EPA listened to Kentucky, which is, some would say, a rare thing, but they listened to Kentucky's plea to allow maximum flexibility in crafting a plan that would address the need to reduce the carbon footprint. And EPA came back and they said, look, traditionally, when we have dealt with clean air pollutants, we've dealt with them at the generation of the pollutants. Here, we're going to look on both sides of the electric meter. And if you can come up with efficiency improvements, either on the power plants, which have a marginal ability to be more efficient and to lower their footprint per ton and per BTU, will allow you to get energy efficiency improvements on the consumer side of the meter as well, and to credit those. So if I can make somebody twice as efficient and lower by half their footprint by making them much more efficient in how they convert electricity, how they use it, how they heat and cool their homes and their offices, their buildings, and the lighting, and all these other areas, then they will count that. Now, Kentucky is in the process of developing a plan. Unfortunately, Kentucky is hamstrung by a bill that was passed during the last legislative session, House Bill 388, which was the industry's attempt to anticipate what EPA was going to do. In fact, it didn't anticipate what EPA was going to do, because what it does effectively is require that all of the reductions be attained on the production side of the meter. That will be impossible for Kentucky to achieve, because there are simply not, without shutting in a tremendous amount of coal-fired capacity and building a lot new natural gas capacity at a much greater cost to the ratepayers, many of whom are extremely sensitive. The poorest of the poor in this state spend 20%, 25% of their disposable monthly income just trying to keep the lights on at night and to keep warm in the winter and cool in the summer. And so that's a great challenge that we're facing. Obviously, the General Assembly will have to revisit the House Bill 388. There's no bill to do that yet. But it's an area that you might want to keep tabs on. What's going on with the 111D rulemaking? Certainly there'll be litigation. As night follows the day, litigation follows the Clean Air Act. But the challenges that have been brought in recent years have been very largely not effective in turning back the tide. With that, I'm going to wrap up and ask if there's questions that you all have on the coal part of the program today. And again, I do apologize. I've got to go back and either be victorious or hang my head in defeat at the end of the day. But any questions that you all have? Well, I want to thank you very much for
on SMACRA. Would you say overall it did good for the country, or I mean, was it sort of worth the regulatory costs imposed?
The SMACRA was the 1977 Surface Mining Control and Reclamation Act. Congress intended to do a couple of things. One, they intended that technology would follow good reclamation practice. They intended that the land, once disturbed, would be reclaimed to a productive use that met or exceeded the pre-mining use. And they intended that the essence of good reclamation would be you reclaim as quickly as you can after you extract the coal. If those are the benchmarks, then the law has been a failure, because after 4 years in which the law was being implemented in an effective way consistent with Congress's intent, the law essentially was placed in the hands of a series of federal administrations who were hostile to the mandate and who set about to dismantle what Congress intended by rewriting the regulations that had been adopted in 1979. Has it resulted in less damage than otherwise would have been the place if we still only had the state lead? Yes, I think it has mitigated some of the most obvious impacts of mining, but it is still a far cry from what Congress intended. On the 30th anniversary, the Office of Surface Mining wanted to give me an award as a citizen advocate, and I respectfully turned it down because there really was nothing to celebrate. After 30 years, there's still a lot of mediocre reclamation, a lot of mountaintops that have been sheared, and very little productive use made of those lands as Congress had intended. So, on balance, it is a good reflection of how a regulatory framework can become captive to folks who are very hostile to its mandate and been rendered ineffective thereby.
Yeah. My understanding that one of the reasons that coal is such a big part of our fuel mix is because the PSC's mandate to provide the least cost fuel. If that's the case, if trends continue, won't flip to sort of all natural gas?
That's a really good question. What Dylan asked is the driver for the reason we are very dependent on coal, the Public Service Commission, which regulates rates and service, requirement that the utilities choose the least cost option. Yes and no. What's happened historically is that least cost never consider the environmental impacts. So we go in there and say, you're not considering the landslides, the folks who die when the coal waste dam collapses and pins them to the wall of their house, which happened to one of my clients in 1990. You're not considering the miners' damage, the black lung, all of these other costs. And they say, yeah, but those aren't factored in. Those are quote unquote externalities. What has happened is now all those externalities have a nasty habit of ingratiating themselves into the picture. They are now regulatory mandates. And when those things are in the mix, the least cost alternative is in fact now favoring natural gas, because it is relatively, the footprint is relatively smaller, at least for the Kentucky-based natural gas production, because we don't do high-volume hydrofracking. We do nitrogen fracking and shallow wells. And it is in fact favoring natural gas. It's also, interestingly enough, the unit price of solar has come down to the point where there is actually, for many co-ops that are customer-owned rather than investor-owned private utilities, you have an actual faucet of wind power and solar with natural gas, and coal is becoming kind of an outlier. So it really is changing. That same driver that historically didn't account for those impacts, as they are now being made regulatory mandates, is now including them in the mix. Yeah.
When I talk to people in the industry, they seem really concerned that natural gas can't be stored on site in bulk by the plants. And that was one of the benefits of coal. And I don't see that getting talked about a lot.
Well, actually, it has been talked about, just not, it hasn't been picked up much by the press. But there was actually a bill that Chairman Gooch, who's from Western Kentucky, chairs the House Natural Resources Committee. It is a concern. We saw with some of the severe cold last year, with the polar vortex that came through, you saw a lot of utilities that were gas-fired very close to the end of their reserve capacity. And because you are typically a utility that is doing natural gas will have redundancies in terms of how it's delivered. But certainly the reliability, both in terms of delivery to the utilities and how you deal with outages or shortages. Cane Run, for example, went down last week. Customers never knew it, but Cane Run was down for a couple of hours because of an electrical problem. They brought it back up, but there was a significant amount of jockeying around to provide replacement power so the grid didn't go down. Those sort of things do take a real consideration of reliability, particularly since now that we've interconnected utilities, each utility doesn't have the same reserve capacity that it used to, when each one of them is essentially standing alone. One of the pluses is that you have a wider range of who you can dispatch and what's the most cost effective. But one of the downsides is it makes us more vulnerable because we're not storing what we need. Now there are some utilities, LG&E for example, does have underground storage for natural gas. And I'm not sure Columbia does. Columbia do.
So not in Kentucky.
Not in Kentucky, but that is an issue. The reliability of any fuel mix is an issue, and how you deal with outages. And there's also the reliability issue. People don't know how long the Marcellus wells are going to produce. Right? Traditional wells in Kentucky, gas wells, will produce 40, 50, and more years. Right? But nobody really knows for the Marcellus and these other horizontal tight shale formations how long that production will continue, because it's also new. 10 years ago, nobody anticipated that these shales would be developed the way that they are, and it really has been. It's that new and that much game changer. But reliability is a very valid issue. Well, thank you all very much for your attention, and I wish I could be here for the rest of the symposium, but thank you for the journal and for Dylan for putting this on.
Thanks very much, Tom. We're now going to hear from Herb Miller, the president of Columbia Gas of Kentucky.
Thank you very much. Appreciate the invitation to be here. Thank you, Dylan. Thank you to the Journal, and thank you to the law school. I think the last time I spoke in this room, I was in law school, and I was speaking to the judges in the good court competition. So for those of you who are students, that fear is still there. I have to issue a disclaimer, much like Tom did, and perhaps the speakers this morning. I am speaking for myself. The opinions that I give, positions I take, are not necessarily those of my employer. So I've got that on the record. I did bring with me, though, my utility bills. And I'm glad I did, because I just noticed my electric bill was due yesterday. So I have to do that. But I'd like a show of hands, just for those of you here in the audience in this room, who here pays a monthly utility bill or pays rent which includes utilities? Raise your hand. Okay. Now I want you to keep your hand up if you look forward and enjoy paying that bill every month. Okay, yeah, me too.
It means I have.
Need a heat. I like that. Good, very good. Yeah, that's the problem that elder retail and regulated utility space is that everybody wants the benefits, but few of us are willing to pay the actual costs that are incurred to get that benefit. When Dylan asked me to speak for an hour, I'm just kidding. He said, speak as long as you need to. I did practice it in front of my dog and my cat last night, and unfortunately they slept through it all. But the good part was they didn't have any questions at the end, so I don't know if I'll get away with that, Dylan, or not. If you look at the outline that I've shared with you, I've tried to give you kind of an overall primer of regulated utility, really utility practice in Kentucky, specifically with natural gas utilities. Natural gas utility business is segmented into three parts. The exploration and production business, which if you can picture the map of the United States, most of which where our natural gas comes from, are from deep wells in the Gulf of Mexico, some deep wells, Texas, Oklahoma, some coming in from the Colorado basins, and recently, more recently, as Tom mentioned, the Marcellus Shale and the Utica Shale in eastern Ohio, Pennsylvania, New York, and West Virginia. And as Tom said, we don't really know a lot about the future of the Marcellus Shale. It's kind of like Mammoth Cave. You know, it keeps going. Every time you knock down a wall, you find more supply. So we don't really know where the end of that supply is, but it has become a game changer. When I joined the gas utility business in 2006, gas prices were at an astronomically high rate. We were selling gas on the retail side at $14 for 1,000 cubic feet. That dropped to $5 per cubic feet a couple of years ago. Now it's leveled off at about $7 per 1,000 cubic feet. So it's about half, and if you look at the NYMEX futures, which is the New York Mercantile Exchange futures, you will notice that natural gas prices are predicted to stay fairly stable between $5 and $7 per MCF or 1,000 cubic feet for the foreseeable future. So gas prices are now reliable and they're stable, whereas it used to be that the volatility of those prices would go up and down with the market, with the supply, with international oil supply and others. The second part of the utility industry for natural gas are the interstate pipelines. The interstate pipelines are regulated by FERC, Federal Energy Regulatory Commission. They're not regulated, at least not very much, by local state regulators. So a state like Kentucky, which is crisscrossed with interstate pipelines, those large natural gas pipelines are regulated at the federal level and not at the state level. The third part of the natural gas industry is the part that I participate in, and that's the local distribution company. The local distribution company takes natural gas off of the interstate pipelines or from wells that are in eastern Kentucky, at least for us primarily, and sells that gas to you, retail customers. We have about 130,000 customers in central and eastern Kentucky. We serve those through about 2,600 miles of pipe. There are 5 large LDCs in Kentucky. Columbia Gas is one. Atmos Energy in central and western Kentucky. LG&E in the Louisville area. Duke Energy in northern Kentucky. And Delta Gas, which is primarily in southeastern Kentucky. 5 large investor-owned LDCs and a multitude, about 2 or 3 dozen municipal utilities that sell natural gas to their customers. The Public Service Commission is the primary regulator for investor-owned LDCs. The outline has the regulatory environment, the list of all the statutes and regulations that govern us, so I won't go through that. I would like to share with you for a minute my perspective on the economics of the natural gas industry. Monopolistic regulation by public service commissions is based on the assumption that regulated utilities are monopolies. That is, they either exist in a market, which is a monopoly, or they behave in a way that in a monopolistic fashion. So, and if Campbell were here, he called me antitrust law. He would say, can the incumbent utility produce the output on an incremental basis at a lower cost than a new competitor trying to come in, which means that they can manipulate the price, or do they behave in a fashion which is in a monopolistic market? Are there barriers to entry? And you would think that if you had to replicate a pipeline system of natural gas, there would be a huge barrier to entry. And so in the traditional sense, in the traditional paradigm of monopolistic regulation, you would think there needs to be those kinds of protections. The first question I'd like for you to grapple with is, do natural gas utilities fall in that same paradigm of monopolistic behavior? Natural gas is a competitive fuel. It competes every day at the retail level for your choice of energy. Do you choose heating oil? Do you choose electricity? Do you choose wood-burning heat, and you can switch and convert between those fuels pretty easily, some with a greater cost and some with a lesser cost. So in my mind, and we haven't gotten there yet in terms of a regulatory paradigm, natural gas regulated utilities are not the same kind of utilities that are true monopolies, such as water utilities and electric utilities, both of which we cannot live without. I don't think there's going to be a time when you see a gas-fired computer at a tabletop, and the electricity that generates, that comes from a natural gas maybe, but you don't have a little packet. And most of the folks in rural Kentucky use propane as an alternative to natural gas. They have propane delivered to their mobile home, to their farmhouse, or to their location, which is far from a natural gas pipeline. The regulatory compact is the underlying unstated agreement, or at least unstated in terms of economic theory, about how utilities should be regulated. In return for the benefit to serve customers, and in some cases to have exclusive territories to serve, the regulated utility gets a benefit of an opportunity to return a fair rate of return. Those are codified in KRS 278-030, which says every utility may demand, collect, and receive a fair and reasonable rate, and in return, every utility shall furnish adequate, efficient, and reasonable service. So there is an obligation to serve, and there is a right to serve. There's a difference. Electric utilities are allowed to have exclusive operating territories, and they must serve all customers within 1,000 feet of the end of their line. Gas utilities and water utilities do not have protected or exclusive territories. Gas utilities, however, must serve customers within 100 feet of the end of their line. Water utilities within 50 feet of the end of their line. So the right to serve and obligation to serve are slightly two different things. Now, what about the recovery of these costs? Because when you get your utility bill at the end of the month, you're concerned about what am I paying for? How much am I paying? Is it fair and reasonable? And am I paying my fair share? The cost of regulation is immense, and Tom inferred that in his talk about how coal companies and electric utility companies are trying to internalize all these new costs that are being absorbed by them. Our billing systems, our meter reading processes, line inspections, pipeline designs and construction, service line connections, emergency response rates, leakage surveys, deodorization. Remember that rotten egg smell? You may have picked one up in elementary school where you actually smelled the scratch and sniff piece of paper. Pressurization in the lines, gas quality, required inspections of our employees like drug testing. All of those are costs. And the subtext of my speech, when I talked to Dylan about the regulatory environment, was who pays, why, how much, and when. When you get your utility bill, that's what you want to know. So under Section 8 of my outline, if you're following along, the why of those costs. Utilities always have to ask, and the Public Service Commission will always ask, what are the costs of service? How much is that utility paying to get the energy fuel to your door? Is it prudently incurred? Are the costs, are the assets invested, used, and useful to the benefit of the customer? Are they known and measurable? Can you adequately predict what those costs are, or is it purely speculation? And are they O&M expenses, which are the daily operation and maintenance costs, or are they capital costs? Because O&M expenses can be recovered dollar for dollar with no markup, no rate of return, or if it's a capital cost, then the utility can charge a rate of return. When are those costs to be incurred? What is the revenue requirement for those costs? Are they one-time costs, or are they recurring costs? Are they now, or are they in the future? How much are those costs? Is there going to be an allowed return on equity for those? And who pays? how are those costs allocated? How much of the system is charged to residential customers? How much is charged to commercial? And how much is charged to industrial? All of those questions have to be resolved on a periodic basis by the Regulatory Commission in Kentucky, our Public Service Commission. Now, some of those costs are not recoverable. For example, because we are perceived as a regulated monopoly, our advertising expense is not recoverable from ratepayers. That's a cost that must be incurred by the owners and the shareholders of the company. We cannot advance our institutional image and say how great we are and try to get additional customers because we're perceived of as a natural monopoly. Safety education, conservation education, those kinds of educational costs are allowed, but institutional advertising is not allowed. Other forms of expenses are also not recoverable. Our charitable contributions are made by our shareholders, not through the ratepayer base. Employee compensation systems for incentive plans, and even if we have an appreciation dinner for our employees, the cost of that dinner cannot be passed through to our customers. That has to be absorbed by our shareholders. And unregulated activities in Kentucky and in many states are also not recoverable in ratepayer rates. So if Columbia Gas wanted to start a separate business of insuring gas lines or installing gas appliances, then that part of the business, which is unregulated, must have its own separate cost structure and organizational structure. The two cannot interconnect with one another. And there is an asymmetrical requirement by our Public Service Commission if the regulated utility does business with its unregulated affiliate. Cost of, book value versus market value. If a utility sells an asset to its unregulated affiliate, it has to sell the asset at the higher of cost or market. If it buys an asset from its unregulated affiliate, it has to buy it at the lower cost or market. So in both cases, the consumer wins because of the asymmetrical transaction requirement. At the top of the third page of your outline, I'd speak about the regulatory lag. It's kind of like the monster under the bed for regulated utilities. I call it the dreaded regulatory lag. And the regulatory lag refers to the time in between when a utility incurs a cost, or whatever it is. It might be for increased salaries. It might be for new pipelines. It might be to buy a new truck. Whatever that cost is, the difference in time between that cost that is incurred and the time it can recover those costs in its rate base from customers. And depending on how long a period of time that is, it may be 1 year, maybe 2 years, 3 years, 5 years, or longer, then the utility is not earning a return on that investment. And as a consequence, that utility will see a decline in its earnings in between that. So during the regulatory lag, there's just an automatic decline in earnings. Now, what does that mean for the utility? It means that it cannot take the return and use that to invest in new assets. It can't get money to repay debt. So its ability to attract credit in the markets is limited as a result of that. So the regulatory lag becomes a very important piece in the management of regulated utilities. Now, our Public Service Commission has recognized the difficulty of the regulatory lag and has tried to address it through various regulatory mechanisms. One is just the frequency of rate cases. In our company's case, we have stayed out of rates for at least 3 years because we know that our customers can't absorb a frequency of annual rate cases. That's not the same way in other states. Our sister companies, as part of the Columbia system, like Pennsylvania, they're in rate cases every year because they're making these huge investments in their system and they cannot afford a long regulatory lag. We're trying to manage our system on a more gradual basis so that our customers don't have to absorb that hit every year. The balancing act is at the third year or the fourth year, whenever it is, you don't want rate shock hitting your customers. For you all who pay gas rates or electric rates, you know that. You like things to be predictable, stable. You don't want things thrown on you after 3 years that you can't afford to pay. So we have to try to balance that out. There are accounting mechanisms such as deferrals where utility can make an expense and defer that on its books to its next rate case, so there's no regulatory lag. Or sometimes we can ask the Public Service Commission for approval for an additional surcharge on the bill. Probably the most frequent surcharge that most customers see on a bill is for accelerated pipeline replacement. In Kentucky, most of the LDCs and many of the municipals are replacing their pipe that becomes corroded at a higher rate than what it would normally replace that pipe. If you look at our system, ours is 2,600 miles. When I came into the company in 2006, we had 520 miles of pipe that needed to be replaced on a more frequent basis. So that's more than 25% of our system was what we call priority pipe. We've worked that down to about 17% of the system over the course of 6 years. But that will be an additional cost or surcharge on your bill. So what about the future? I would say that the future brings, Tom mentioned it, the concept of externalities. In the business of the utility regulation, externality means all those things swirling about that are not part of the traditional rate-making process. Probably for gas utility is a concept called DIMP, D-I-M-P, Distribution Integrity Management Programs. DIMP requirements come from the federal government, and they are particularly there because of some of the pipeline explosions that have occurred in California and other places where pipelines have become so deteriorated that the welding joints or whatever it is that's happening inside that pipeline expand, release, and then there's ignition point. And people have lost their lives. So DIMP programs are required of every utility. They ask you to assess your risk and to implement risk mitigation practices. It is not a funded mechanism. So if utilities are accelerating their risk management and implementing practices for safety, those practices come with a cost. And customers are going to end up sharing in that expense. And part of the balancing act that regulatory commissions will be faced with is who do we share that cost with? Does it all fall on the backs of the ratepayers, or does some part of that become shareholder expense? And if it's all customers, which customers? And then how much? What percentage do they pay? Is it a service line problem that affects only retail customers, or is it a mainline transmission problem that affects commercial and industrial customers as well? Another future externality is environmental regulation. And there are some issues where some cities have been concerned about methane releases. You know, natural gas has a large component of methane in it. That's what causes it to burn so hotly, and that's why manufacturers love to use natural gas in their mechanisms. Methane release expectations will become more frequent. I noticed today that NOAA, the National Oceanic and Atmospheric Administration, has stepped back a little bit in its assessment of methane releases. They use airplanes to fly over natural gas fields, and they measure the amount of methane in the air. And up until recently, it was thought that maybe between 6 and 12% of the methane that is taken out of those wells gets released into the atmosphere. Now they think maybe it's more towards 1%. They're not sure. They're going to be doing some more studies. Energy efficiency. Tom talked a little bit about that and where the public service commissions expect energy efficiency practices to fall. Is it on the producer? Is it on the consumer? There is a proposal with the Department of Energy in Washington that will require natural gas furnaces to become more efficient. Nobody has a problem with that. Everybody wants to have efficient appliances. But that means an increased cost to the consumer. If you go from an 80% efficient natural gas furnace to a 92% furnace, then you'll probably experience maybe a $2,000 increased cost in that appliance and in the installation for that appliance. So what is that going to be for natural gas companies? Shale gas, use of natural gas for electric generation, renewable fuels portfolios. There are states that require electric companies to use in their electric generation renewable fuels. Kentucky is not yet one of those states. There is an encouragement, but it is not a requirement. There is a bill, House Bill 299, in our legislature, which gets introduced every year to require a required renewable portfolio for electric companies in Kentucky, but it has not passed, at least up until now. So, externalities for the future are many and varied for the natural gas industry. Thank you again for allowing me to be here. I will take any questions that you might have. Bill?
You mentioned risk a little bit. Could you talk about the biggest risk that your industry faces?
The question is, what are the biggest risks to the natural gas industry? I would say two. One is pipeline safety and the cost attendant to that. There is a greater expectation on the part of all of us to have safer pipelines. What that's going to mean for natural gas companies is that not only will they spend more money investing in the replacement of older pipelines, but they'll be spending money in terms of training people to replace those lines. It's going to be a huge dollar. The second risk is really no different than facing most industries, and that is the cost of doing business. The cost of doing business is going up for everybody, whether you sell clothes at Macy's, whether you're a restaurant owner, or whether you're in the natural gas industry. The difference in the regulated utility business is that before you can raise your rates, you have to go to a regulator to get approval to raise those rates. Whereas if you're in a non-regulated industry, you can raise or lower your rates as you think the market will bear. Yes, the back.
Yes. As you know, Kentucky is a very coal-proud state. Our public perception, and even those with American Idol, know coal keeps the lights on. What has it been like for you as someone who's been pushing natural gas? Have you had any pushback or kickback from local and public or state regulators or even the public in general?
Well, first I want to deny that I've ever had a kickback. But in terms of pushback, well, the coal industry, it's been a great industry, and it's done a lot. But as we all know, it is so intertwined with the declining economy of Eastern Kentucky that it's become very sensitive for the elected officials in those areas and the people who work in those areas. To the extent that it supports the economy, I've been an advocate for cheap coal. It is what's kept businesses coming into Kentucky and what can keep them here. The question is, how long can that happen, can that occur, and what price are you paying? As a natural gas business person, I would love to see more natural gas used in mechanisms so that we can use coal-fired power plants to convert to natural gas. But I know what that's going to do to the economies of Eastern Kentucky. And there's some counties in Eastern Kentucky that actually declined in population between the two most recent census. Will that continue? How much is that impacted by loss of coal jobs? It's very tough. And I think that the elected officials who are involved in the SOAR organization for Eastern Kentucky, that's a challenge for all of us to face. Sorry, there's another question. Yes. Yeah. Okay. Yes.
On your future mentioned here, you've got a couple things that some people might argue different ways. One is the shale gas. Those that talk about all the shale exploration say that that's going to keep prices down and going to have exponential growth and availability, so the gas will be cheap. On the other hand, we do start using more natural gas for the generation of electricity and transportation, those sorts of things, it will eat into that supply. So, what are your experts telling you? You mentioned that NYMEX is showing it's going to stay for the foreseeable future about 5 to 7. Do you and your prognosticators agree with that, or do you see that it's going to go up or down or remain the same?
When our prognosticators look at NYMEX, they're not second guessing NYMEX. Figure that the market has already built into those costs what's going to occur with the additional shale gas that will come online. So I think both things are going to happen. I mean, I think you're right. The supply will keep prices low, but what will keep them stable and not going up a whole lot is that we're going to become more efficient in how we use that natural gas. We may see more use of that fuel, such as a transportation fuel. One of the things that I've been pushing for in Kentucky is to be able to adopt natural gas for use in vehicles, and we can do that without competing for coal-generated power plant usage. So, it's a win-win for everyone. Unfortunately, that Kentucky is one of the last states to come on board when it comes to natural gas vehicles. We don't have very many natural gas fueling stations in Kentucky. In your area, Don, in Somerset, I think there is one. Louisville, there's one in Western Kentucky, but in many states, there are hundreds of natural gas fueling stations. So natural gas is a part of the energy choice for vehicles. It is not there yet. Yes.
That was actually my question. Farmers have started everything to semi trucks on the market. How can natural gas converting to semi truck market? I don't have very good fuel. I can't get out and back without getting tank that's sure it doesn't really have a plan for semis and distributors carry the same supply.
Kentucky has, the question is, what regulations or policies exist in Kentucky to advance natural gas vehicles? There are not very many policies or practices set up for that. One of the problems is that we are not a big natural gas producing state, so the political power of natural gas producers that might exist in other states, such as Oklahoma or Utah, Texas, even Pennsylvania, and now Ohio with the Marcellus and Utica shales. The political strength of the oil producers, the natural gas producers, have resulted in programs for that. I would love to have my fleet at Columbia Gas, our vehicles, to run on natural gas, but we don't. And why is that? It's because we're not a fixed base fleet of trucks. We can't come back to the same place every night. We're driving in places that have no fixed routes where you could put a fueling station. And that's the key for a fleet of trucks. Is to, if you want natural gas as a vehicle, right now you have to have a fixed base fleet of trucks. So UPS and Federal Express on a national basis are both converting their fleets to natural gas, at least in large part. The Lexington Fayette Urban County government has started a program to bring its garbage trucks to natural gas, so they're experimenting with that. LexTran, which is our mass transit facility in Lexington, is going to create a fueling station and buy 7 or 8 trucks in the next year or 2, buses, for natural gas. So you've got to have a fixed base fleet to make it worth your while. If you don't, right now in Kentucky, gambling if you buy a natural gas vehicle.
Kurt, do you think that's a politically based thing? In other words, are there so many more gasoline distributors and people that ilk that would be fighting the installation of natural gas stations? Because Secretary Peters seems to be a very progressive, forward-thinking type of Energy Secretary that if the state was to propose something like that, there would be a big opposition from those in the natural and the gas movement.
The question is, would natural gas vehicles present a threat to gasoline distributors, producers, and sellers? And I suppose it would. I mean, theoretically, any competition would do that. I haven't seen that competition rise to the level of political opposition. I just think it's more or less, it's one of the last things people think about.
Thanks.
Thank you very much.
Okay, we'll next hear from Dean Jim Huffman talking about natural resources and regulation.
Well, thank you. It's a pleasure to be here. I think we've learned both from this morning's discussion of equine law, which I didn't even know existed until I came to Kentucky, and the two speakers this afternoon. Regulation has a lot of costs. It's complex, and presumably it has a lot of benefits. And I think what I want to do is look at the issue of regulation, particularly environmental regulation, from kind of a 30,000-foot level, which won't surprise you since I'm an academic. That's what we academics tend to do. And let me start by saying I think we all come to issues like this with strongly held preconceptions about how the world works best, or how the world is structured. I remember way back when I was in graduate school, Fletcher School in Boston, there was a fellow from Kentucky in my class, and we were both baseball fans, and I discovered he was a Cincinnati Reds fan, and I thought, well, that's weird. It's a guy from Kentucky being a Cincinnati Reds fan. He said, well, it's just across the river. He was from northern Kentucky. And I had never put that together in my western Montana country boy mind, that the North and South actually do come together somewhere. Or another example, my sister-in-law is a serious horse person in Massachusetts, and she has these horses that they bathe them after they've gone for a jog, and they put them in stalls at night, and they put blankets on them, and they feed them special food. And I grew up with horses in Montana, where you just took off the saddle and slapped them on the rump, and off they went into the pasture, and you didn't look at them again for days until you wanted to go for another ride. And I'm still struggling to get my mind around these two conceptions of how you take care of horses. Well, let me try to offer this 30,000-foot look at regulation, and as I say, particularly environmental regulation. And I'll come at it from a perspective, really an economics perspective, although I'm not an economist, and I know we have at least one economist here, so I'll speak cautiously. I really see regulation in general, environmental regulation in particular, as simply a resource, as dealing with resource allocation. You know, we all drive automobiles. We know they're dangerous. We know that X number of people get killed every year in them, many, many more get injured. We could all drive vehicles in which our chances of injury and death were almost zero. We all drove tanks, for example. We could run into each other with very little consequence. We don't, because the expense, the cost would be enormous. It's a resource allocation decision. We'd rather drive, some people even choose to drive little sporty cars in which you have no protection and pay a large amount for those cars. So I think it's useful to look at any kind of problem we're talking about, whether it's human safety, whether it's protecting the environment, whether it's protecting the health and safety of the population as a resource allocation problem. And I think if you're thinking about natural resources, there's a handful of institutional arrangements we might use to deal with those resource allocation problems. We could just treat them as a commons. They're just out there. We could say this auditorium is a commons. We all came in. We took a chair. And while we're in the chair, it's really our chair. Nobody else can sit in it while we're sitting in it without some controversy. And there's enough chairs here given the size of the audience, that a common system works just fine. But if this were a rock concert or something else, we need another system for allocating the resources, the limited number of chairs. And the reality is, in most of our life, and increasingly this is true, resources are scarce. And as population grows, consumption increases, resources become ever scarcer. And so the commons doesn't really work very well. Well, what are our alternatives? Well, one obvious alternative is we can use private property. You could have bought a ticket for one of these seats that had the seat number on it, and that would be your property during the duration of whatever event you bought the ticket for. That's your private property. And we use that widely in this country, much more widely than some other countries on the planet. But we also know that those private rights that we have get regulated in various ways. So we can have a regulated private property system, and that's pervasive in the United States. There could be rules about how you use this seat when you come in. Maybe they'll say you can't bring any coffee for fear you'll spill it on the seats, or you can't put your feet up on the seat in front of you, either because that'll disturb the property rights of the person in front of you, or might damage the furniture. So that's an option. We could just make it all owned by the government. We could have public property as an institutional alternative. That's what we do out west with about half the land of the western United States. Not counting the amount that's owned by the states, it's owned by the federal government. The state of Oregon, where I live, it's about 50%. State of Alaska, it's over 90%. Nevada's about 90%. Washington's only about 30%. It varies, but on average, 50%. Well, when you do that, and those resources are controlled in that way, the method you use by which to allocate the resources that are there are very different. You're really using a political method. You're allocating them by some political process, although you may use private rights by agreeing to lease land for somebody for a term of years, and you create a temporary private right. And then it turns out where we do have these publicly owned approaches, we end up regulating. And we've done that particularly in the environmental area. NEPA is really all about regulating public ownership. It's a process for making sure that public officials who own the Forest Service, the Bureau of Land Management, or the responsible agents for the government, that they have complied with a certain set of rules, because we found that they weren't managing as well as we might have liked to do. So I would just say there's probably other alternatives, but there's 5 different ways we might manage these solve this scarce resource allocation problem. And the reality in our society is that we've got a mix of all that. There's still some commons out there. Maybe they shouldn't be. Air and water to some extent remain just available for whoever comes and takes it, less and less so, particularly in the case of water. Private property is everywhere. There's a lot of public ownership, not just in the West, and it's all regulated in various ways. So let's look at the regulation piece of that. How should we look at regulation? Well, first of all, it's always implemented for a good reason, or purportedly for a good reason. That is, that there's never been a person who advocated for the regulation of private property or of government management of public property who didn't claim to speak for the public interest. It is in the public's interest that we're doing this. Now, we also know that sometimes there's a lot of what economists call rent-seeking going on. Right at the outset, they may say, let's regulate the number of taxi decals that can be issued in the city of New York or many other cities. And they will articulate a lot of reasons we'll do that relate to public safety and public interest. But the reality, of course, also is that they're regulating supply, and thereby helping those who have life. We lawyers are in the business, those of us who are lawyers, are in a business that regulates supply by having a bar requirement, bar admissions. And nobody in the bar will say that the purpose of that, well, some might actually confess up. The purpose of that is to regulate the supply of lawyers so that they can keep their fees high. We were just talking last night yesterday about Florida, right? And they're going to charge more as you age. It's bad news for guys like me if you want to join the Florida bar, clearly for the purpose protecting the existing practitioners, right? So although we know that rent seeking is going on all the time, we never talk about it. We promote our regulations always as if they are in the public interest. But they all, whether or not they were legitimately enacted for public interest reasons, they all become subject to potential rent. Once they're in place, they become a vehicle to try to be manipulated by interests who might gain through the regulation. It happens in environmental regulations. You notice a lot of times large industry, who initially were reticent about a lot of environmental regulations, have become strong proponents of a lot of environmental regulations. And for one reason is it protects them against competition by smaller enterprises. I would say the reality in the case of environmental regulation is that if you're a small business, I don't know what qualifies as a small business. My former senator from Oregon, Gordon Smith, used to have a pea, still has a pea cannery out in Eastern Oregon. He got in all kinds of trouble with the EPA and the federal government about non-compliance with, even though they were self-reporting whenever they discovered them. But the reality, Gordon would say, is impossible for them to know that they were in compliance with every law. They couldn't afford to. They try to be in compliance with those that they know are most likely where they're at risk, but they can't possibly be in compliance with all of them. My son's in the restaurant business in Portland, Oregon. He hasn't a clue whether he's in compliance with half the laws that apply to him. He doesn't even know what half the laws that apply to him, and he can't know. He can't afford to know. It's just too expensive. So the large businesses have often benefited significantly from regulation by limiting markets. So I think one of the challenges that we face is in enacting regulations is in being clear that we're going to deliver benefits in the form of what passes under the broad label of public interest that are in excess of the costs that are going to be generated by those regulations. You're along about the costs that are from Tom Fitzgerald, about the costs that are generated in the coal industry and how that's impacted the economy of this state. Those costs may be well worth spending, but we need to know that that's the case. And if not, we should think about ways to reform those regulations or eliminate those that are not cost effective. Now, if one way that we have tended to look at regulation in the environmental case, and let me just back up a step and say, look, environmental regulation has really blossomed since about late 60s, 1970 to today, although we haven't had a lot of big national legislation over the last couple of decades. And those regulations have had enormous impact on the economy of the country and on individuals affected, both positive and negative impacts. And I would say on balance, they probably delivered more positive than negative. But there is a lot of negative. And one of the questions I always ask myself and ask my students is, could we have gotten all of those positives at less cost? Could we have gotten them with doing less damage to the small business guy or the other people, to those who have to comply with those regulations? And I think there's ways we can get at that question in a fairly objective way. Many years ago, about the time, or very early in that federal legislation, there was a little book called People or Penguins, A Case for Optimal Pollution, written by William Baxter, who was subsequently the head of the Antitrust Division in the Justice Department, I think under Nixon. And Baxter was a professor at Stanford. And basically his point in this little book, and the book is still well worth reading, I think, is that the reality is that nobody really wants zero pollution. Zero pollution makes sense to nobody. And partly he was reacting to a lot of what still is a strong theme among environmental advocates, which is zero pollution is where we ought to be trying to get. That's the best thing we can do. And to the extent that they make that argument on moral grounds, I'm not in a position to argue with it. We can argue morality. But if we're talking economics, and I think we need to talk economics, Zero pollution never makes sense. Optimal pollution does. And what does that mean? It means we get the maximum amount of productivity for any given amount of pollution. And if we can reduce that pollution and maintain that productivity, we should. But at some point, when we reduce the pollution beyond a certain point, we will lose more productivity than we, loss of gain, that we won't gain as much in protection, environmental protection, as we lose in the cost of reducing the pollution. And that doesn't make any sense. And so I recommend that little book to you. But the way we should think about it, I think, is using just basic market economics theory. And a lot, just my two preceding speakers have talked economics, they've talked externalities. And if you look at a lot of the justification and explanation for much of the environmental regulation that exists today, it's all rooted in market failure theory. So what is that? Well, the basic theory, basic market theory is that we get efficiency in the terms that microeconomists use the term. We get the most return for any given amount of resources as we can. How do we get there? Well, if we have the public ownership model, we've got public officials trying to figure out whether we're getting more net social value out of keeping the forests of the Northwest as habitat for spotted owls or allowing more harvesting of trees. Now, that's a hard case to call. It's hard to estimate what those costs are, what the benefits are of protecting the spotted owl. The costs are easier to estimate. We know, for example, that pre-spotted owl, there were about 10 billion board feet of timber being taken out of the state of Oregon off of federal lands. Today, it's under 1 billion. You can imagine what that has done to the timber industry in the state of Oregon. Now, maybe those costs were way down, maybe not. But if you're a public official trying to make that judgment, it's a pretty hard call because we really don't have any good measure of what those benefits are on protecting the spotted owl side. Well, in a market, we're getting to what economists consider efficiency because private parties are transacting with each other. And every transaction, if it's voluntary, if it's a free transaction made with complete information, we know both parties are better off. And you can say, oh, wait a minute, the transactions aren't costless and nobody has complete information. Both true. That doesn't make the assumption unworthy of using as a way of analyzing what would be the best if we could achieve those conditions of a real free market. So in market theory, we would get the most efficient allocation of air, water, petroleum, whatever we're talking about, based on these market transactions. And why don't we? Because we have market failures. And what are the market failures? Well, basically, one is externality. We got people impacted who weren't parties to the transaction, and they're bearing costs. Now, there's an interesting question about whether or not, given the existence of property rights, we should be concerned about those other costs. But that's a debate among some economists. But let's assume that we should take account of all those costs on other people who are third parties and not involved in the otherwise mutual agreement. What do? Well, we can regulate to internalize those costs. And I would say the vast majority of environmental regulation has been adopted pursuant to that frame of reference. We're trying to internalize costs. So we're going to make those coal guys pay now for all those environmental costs that they were imposing on the rest of us. That's going to up their cost of doing business, which is going to up my costs of buying the electricity from the coal that they generate. But if we got all the calculations right, then we now have corrected for the market failure and we have a truly efficient allocation of scarce resources. It's not easily done, but it's a very fact-driven way of trying to reach that decision, rather than just saying pollution is bad, let's regulate it, without any sense of how much to regulate it and in what manner to regulate it. There are a couple of other sort of market failures that we deal with. The public goods problems are significant problems. So You know, highways, there's a lot of goods that will not be provided privately for enforcement reasons, or transaction cost reasons, or a multitude of reasons, and that the public provides. And we have similar challenges figuring out which are truly public goods and how much of them to supply. But that's another category of market theory that economists talk about. Of course, the third is monopoly, which we heard about. If you have a monopolized situation, you don't have a competitive market, and you're not going to get those efficiency benefits. I would also point out, if we're going to use this externalities explanation for when to regulate and how much to regulate, we should not discount the reality that government has its own transaction costs, which are often extremely high. Look at, for example, the Keystone Pipeline. How long has that been? Now, we know that's all about politics, but it's all justified in the name of regulatory processes. And so the president says the reason that he's not willing, that he's going to veto this thing, is because the process has not run its course. Well, the process has been going on for 6 years. There's some serious transaction costs there. No business would stay in business if it took 6 years to make any decision. So there are transaction costs in government, and there's rent-seeking in government. Government officials have an interest in feathering their nests and having nicer offices, having bigger staffs, and having bigger budgets. So all of those behavioral things that lead to rent-seeking and market failures on the private side exist in the public side as well, and need to be recognized. So what it all comes down to me is that incentives matter. Now, there's a simple little statement I'm going to say a lot. Incentives matter, right? So if we're going to regulate, let's look at what incentives we're putting in front of the people whose behavior we're trying to influence, because that's what regulation is all about, is trying to influence people's behavior so they behave differently than they would in the absence of regulation, on the theory that we will then get more efficient allocation of those scarce resources, or we might be driven by a purely moral objective. But whatever our objective, incentives are going to make a difference, both for the private actors who are being regulated and for the government officials who are regulated. So in the private arena, that's why property rights and contract rights are essential to a functioning marketplace, because they are what create and preserve the incentives for people to behave in the ways that they behave. If your property right says you can do whatever you want with your property except what the government says you can't do, you're not going to invest a lot in that property. Or if you enter into a contract with somebody else to engage in some kind of a business transaction, and it's subject to very high levels of uncertainty about what regulations might be affecting that transaction, your incentives are going to be different than if you have a high level of certainty about what the relationship is going to be. Liability rules are similar. We know what the liability rules are, then we can know how to behave going forward, and that will affect the incentives we have. Taxes are similar. And so we use taxes to try to influence people, or we use tax, now going to be called tax expenditures, to influence people's conduct. We subsidize the purchase of a Prius because we know that incentives matter. The higher you make that subsidy, the more people you're going to get in Priuses. And so regulation is just the same. When you regulate, you affect people's you affect people's incentives. You can fine them. You can even use criminal penalties, which we do in the environmental area, and actually several areas. And so the last thing I want to say, given we're all on board now that incentives matter, is how can we make incentives matter to benefit the environment in a regulatory world where there's lots of people out there putting their natural resources to use, whether it's coal mining or soybean raising or horse farming or whatever you're doing with natural resources. And in that regard, I've been part of a sort of group of people for several decades who have come to pass under the name free market environmentalists. Now, there's some in the environmental world, probably many in the environmental advocacy world, who think we're a bunch of charlatans in sheep's wolves and sheep's clothing, masquerading in the name of environmentalism when we're really out there to rape and pillage. So let me try to convince you that I'm not interested in raping and pillaging the environment, but that I think there's a lot of power in the marketplace. There's a lot of power in these incentives to get people to do good environmental things. And there's been a pretty dramatic change. We in this cabal like to think we've had some influence. Maybe it's just happened anyway. But there are many examples of how these market incentives have been used to pursue environmental objectives. Probably the most obvious impacts the energy industry are tradable emission permits. What is a tradable emission permit? Well, it's an alternative to a command and control system where you say, okay, you can emit X amount of pollutants. What does the utility do when they're told that the maximum they can emit is X? Well, they figure out how to get to X. What's their incentive to get below X? They have no incentive to get below X. Now maybe they're really good, socially minded corporation, and they'll get below X a little bit because then they can publicize that in their advertising. But the reality is, at the end of the day, appealing to people's social consciousness really has been a very ineffective way of accomplishing almost anything. People will do it for a while, but then they start realizing it's costing them a little extra, it takes extra effort, and they stop. So in a command and control system where you say, here's the standard you have to meet, that's the basic incentive, is to meet the standard. In the tradable emission system, what you do is you figure out what that aggregate level of pollution is that we are going to accommodate as a nation or a state or whatever our jurisdiction. And that is not a market decision. That's a purely political decision. We figure out what that is, then we figure out how many people we have who want to put their pollution in under that ceiling. And in a lot of ways we might allocate it, we can sell them, we can just give them to the people who are currently polluting and say, okay, you now have X units, and here's what you can do with your units, however we allocate them to you. You can keep using them, just don't, and each one of those units allows you to put out a wide amount of pollution. But you can sell them. If you can figure out how to run your operation on Lex, let's say you've got 10X and you can figure out how to run it on 9X, you can sell the other one. Now I've got an incentive to get below 10X, right? I've got an incentive to get to 9X because I can sell that other one. And now we're going to get, and now somebody else who pollutes but also produces goods can start producing. So we've got that same amount of pollution, but we're getting more productivity from the same amount of pollution. And that's a good thing. Everybody ought to think that's a good thing. Nobody can be against efficiency. Whatever your driving force is, you've got to think it's better to get more of whatever we're trying to get at less cost, or at the same cost that we were getting less for previously. And so that's the basic idea of tradable emission permits, and we're doing them everywhere. And there's lots of studies being done about how effective they are and how the markets are working. But they've been widely embraced, including by some, but not all of the mainstream environmental groups. There's a lot of other areas. Water marketing is a big issue out west. Historically, the water was allocated in the west on an appropriation system. First come, first served. Whatever you divert from the river is yours, and you get to use it in perpetuity. And if you diverted it before the guy next to you, you get yours and he gets cut off. The supply gets to that point. Very, 2-year-olds know this system, right? First in time, first in right. And the problem with it was there was all kinds of stuff superimposed, a lot of it done by people trying to seek rents in economics terms. They limited those transactions and made it hard for you to transact. And it's not a simple market because if I were to sell, let's say I have water that I'm using and I'm consuming half of it and returning half of it to the stream. I sell it to somebody who's going to consume it all, that's going to have be bad news for the people downstream who might have superior rights. So it's complicated to make the thing, to exchange these rights. But there's been a lot done in the West in the last couple of decades to make water rights more marketable. The best illustration of why it's so important, if you look in the state of California, and again, this is in the news, they're looking at more desalinization of water for large cities on the California coast. What does it cost to desalinate an acre-foot of water? I know 2 decades ago it was $2,000. It's probably a lot more than that now. What does an acre-foot of water cost for a farmer in the Central Valley of California? It's probably $25, $30 an acre-foot. Now, if you have a market going, that is not going to last. You can't have some people in the market paying $30 for the same amount of water that other people are paying $2,000 for. It's absolutely crazy. And that's all made possible by the federal government and heavy subsidies of agricultural water. But if you have a market where it's truly competitive and you can, and people can, those farmers have an incentive to sell that water to people who are willing to pay a much higher price, agriculture is going to get a lot more efficient in water use, and consumers of water in the cities will get their water for less. Congestion pricing on highways, it's happening everywhere now, right? You get a little barcode. If you drive when traffic's heavy, you pay more. If you drive when traffic's light, you pay less. It's basic incentives. Driving, fee hunting. I don't know if you do that here, but out west it's very controversial. A lot of people hate the idea because they say the public owns the wildlife. But people pay money to go on certain people, private ranches and hunt. You might have to pay $2 grand. You can go shoot an elk. Or you can pay the government $25 for an elk permit and go on public lands and probably never see an elk. Trash collection fees based on how much trash you're putting in rather than just a standard fee for everybody. I mean, the list goes on and on. My only point is that I think there's a lot we can accomplish in terms of environmental protection that will benefit the environment, that will benefit natural resource users and developers. I'm not saying that there are some command control regulations that's not a good idea. Some things I think we cannot find market solutions to because we can't create right systems that are workable and enforceable. But I think we've had a lot of extra expense that we didn't need to have if we'd been more sophisticated in thinking about the environmental protection problem in agriculture or in a multitude of other areas as a basic resource allocation problem where we just need to get the incentives right, and oftentimes markets are a good way to get the incentives right. Happy to take any questions or disagreement. If this were a class at Lewis and Clark, I'd get a lot of disagreement. Yes? Yes, there has been opposition, and I would say some of it comes from a perspective that says that what you're basically doing is effectively granting a right to pollute, and some would say that's even immoral, or they object to the idea that you can have a right to pollute. So there's been strong opposition in a lot of the mainstream. The Sierra Club, for example, is basically an opponent of most of these market approaches. Environmental Defense Fund, I think they're now back to being called Environmental Defense Fund. They were Environmental Defense for a while. They have been strong proponents of market solutions, both in air pollution and water. So there has been opposition. I certainly have a lot of my students. In fact, I can't get gas even to first base with a lot of my students, which is why I started out with making the case that we've got these sort of blinders on, and if we can remove them, I think we can see them a lot more. Yeah.
I mean, the trading of credits is a great abstract system, but it denies the very real geography of specific places being impacted and specific people. Is there any chance of building into the system specific reparations to the people who are harmed by the pollutants that are moved around? under this credit system?
Well, that's a good question, and I'm not sure that there are sophisticated solutions to the problem. I think an issue which often is not considered is if we create, let's say we're going to sell these permits rather than just grant them to whoever. And there's a lot of opposition just granting them to the current polluters because they kind of just fallen into a pot of honey when that happens. So if we're going to sell them, what happens to those proceeds? Where do they go? My hunch is that most of them just go into the general treasury and get what happens to a lot of government money that comes in ways like that. And maybe it ought to be going to compensate people who have suffered those external costs that were corrected. I think that's a very legitimate claim, and a system might easily be put in place to accomplish that, although I'm not aware that has happened. And you do suggest another aspect of the whole environmental protection debate, which is the environmental justice side of it, about who's really bearing these costs. And the harsh economic reality is that those costs are going to be borne by people who live in places where real estate is cheapest, because that's where both the polluters would rather be, because cheap real estate, they don't need expensive real estate. But that's also where the poorest people in society end up living. And that's a legitimate concern that I think we have to address.
You mentioned Keystone Pipeline earlier. I was interested that Congressman Amash, I guess he supports the pipeline but voted present on the bill to build it because it's exhibiting only one private corporation from like all the government regulations and rules and licensing requirements. So do you think it's a better approach to allow kind of piecemeal grants to big organizations like Keystone to build their pipelines or whatever, or is it better to just try to get rid of the rules and regulations entirely? Like, I don't know if that's.
Well, I mean, I'm not an expert on all the regulations that are to which the Keystone Pipeline is being subjected. My understanding is that the president's role in this has to do with the international piece of it and approving that through the State Department. And I think that's clearly there has to be some approval mechanism on the part of both Canada and the United States when you have a trans-border project like that. So I think that is certainly legitimate. And I think having some regulatory system in place to to minimize the impacts of that pipeline as it traverses the countryside makes sense. To me, the issue with Keystone is it should have been resolved 5 years ago, up or down. It just makes no sense to drag it on to this extent, although it really is as good an illustration as we can find of how when any issue that regulation involves politics, that's what it's all about. One of my good economist friends says that we shouldn't call the lands out west public lands, we should call them political lands, because they really are. That's how they get allocated. The same is true, of course, of regulations. They're political decisions. I think those of us interested in having effective regulation and effective allocation of scarce resources should do our best to influence the politics so that those regulations achieve those purposes rather than rent-seeking purposes, which are pervasive and I'm afraid unavoidable. And of course, as we all know, once you have them in place, it's extremely difficult. And you got these people generating these rents. Then it's they got all these vested interests in the existing regulatory system. It's extremely difficult. Shame. Thank you very much.
Thanks, Steve Hussman. And we're now going to hear from Balin Linnekin, who's talking about food safety regulation. He's the executive director of the Keep Food Legal Foundation.
Thanks very much. I'm going to be inventive and use PowerPoint. I want to thank and note particular order, the law school, the journal, my fellow panelists, and everyone in this room for coming out. Enjoyed my time here so far. I just found out that my flight is and I just canceled. So I'm going to be enjoying some more time here. Which is great. Anyways, I'm going to be talking about Food Unchained. Let's see. There we go. So what is that? So what do I mean by that? I'm writing a book right now for Island Press, which is an environmental publisher about ways that food regulations often impede sustainable food practices or promote unsustainable food practices. My argument in the book, as I say here, is that eliminating many of these regulations can actually promote a more sustainable food system and foster food freedom, which I believe in my bio is described by my definition. So I'll just reiterate again: it's your right, everyone's right to grow, raise, produce, buy, sell, share, cook, eat, and drink the foods of your own choosing. They can be sustainable. They can be McDonald's. Your rights are the same. And so I guess I should define sustainability, which I think has some overlap with the efficiency definitions that were just used. It's a set of practices that seeks to maximize the food producer's profit, which is one element of sustainability that you may not always hear about, but I think it's important. If you can't make a profit, then you're not sustainable as a farmer or a food producer. And minimize the negative externalities. Again, I'm not an economist, but I like to throw around those terms every once in a while. Negative externalities of farming and food production. And by way of making you jealous, I just came from Curacao, where I was there for a week. It's very warm. I have a bit more of a pigment than I normally do this time of year, which is great. So I visited an ostrich farm there in Curacao. I'd never been before, but it's very dry and rocky, despite the fact that it's in the Caribbean. It's not really good for farming, but one thing that apparently flourishes there are ostriches brought over from Africa. And so they raise the ostriches and they sell the meat in Aruba. They sell it in their restaurant. I had ostrich. I love a good burger, but a good ostrich actually is quite tasty for your farm. You get the opportunity. And they have a problem where they can sell the organ meat. No one in Aruba was particularly interested. No one in the restaurants were interested. So they imported some crocodiles. The crocodiles love the ostrich organ meat, heart, and all those things. So it's a sort of a closed loop as much as can be. I don't know where the pellets that the ostriches eat come from. They may be produced outside the country. I'm not sure, but it's a largely closed loop. So that's what sustainability aspires to. The farm offers tours and seemingly have an economically sustainable operation. So anyway, so as any good law review article does, I'm giving you a roadmap here to talk about some unsustainable or bad food rules. I'll talk about rules that restrict sustainable commercial food practices, rules that promote some unsustainable food practices, and then I read a weekly column for Reason Magazine. I wrote a column a while back, which was I say tomato, you say tomato, but no. So I talk about people who want to say grow their own vegetables, and then the government tells them thanks to zoning or other things that they can't. And then I'll talk a bit about some existing good food rules. It's not all dire, and then propose some principles for moving forward. So the general thesis of the talk here in my book is that removing many of the regulatory shackles, chains that bind America's food system can help ensure a more sustainable food system. And I think that may sound odd to at least some in the room. I think that others, Michael Pollan, for example, certainly isn't advocating for fewer regulations to arrive at a more sustainable food system, even if he and I would be happy with some elements of the food system looking exactly the same. The outcomes, ways to get there, disagree about. So the problem here is that small producers often are more sustainable, and yet rules often favor bigger competitors, or just simply prevent the small producers from engaging in practices that they would want to engage in. I have here a printout. It's from a Time magazine article from April 20th, 1942. And this is, I think, probably my favorite. It's 360 words long. Probably my favorite article ever. It's called Citizen Roosevelt. It's about FDR and how he's grumping about having to pay his income taxes, which is hilarious. Anyway, so the second to last paragraph talks about how, well, I'll just read it to you. So Citizen Roosevelt might even have a victory garden soon. Does everyone know what a victory garden is? I had a plot in a DC victory garden for 6 seasons, and my neighbors were Gene Wallace on one side, whose dad was the ag secretary who invented farm subsidies, and Sandra Day O'Connor, her husband, on the other side. So it's a very DC thing. Citizen Roosevelt might even have a victory garden soon. Mrs. Roosevelt planned to plant one on the White House grounds. Hyphen, please listen closely. If the Agriculture Department, that's the USDA, skeptical of amateur farmers, decides that the soil is fertile enough to make the garden worthwhile. So the USDA in 1942, skeptical of amateur farmers, and actually had to give Mrs. Roosevelt the green light before she could plant her little victory garden. Michelle Obama planning her victory garden, which I visited with my undergrad students, which is great. I don't think she faced any of the same challenges. And I think that Ag Secretary Bill Sack probably would have been canned immediately if he had even suggested that he should have some sort of input into whether Mrs. Obama has her garden. I think rightly so in that case. Anyway, so the USDA has, I'm arguing here, sort of a long-standing hostility towards small food producers. There's the Schechter brothers poultry case. There's Roscoe Filburn of Wickard v. Filburn fame. He wanted to make bread with some wheat that he grew, as you all read in common law class. It's still good law, that the government can tell him no, he can't. There's Earl Butts, who under President Nixon said that farmers should plant fence post to fence post to maximize their output. And then there's the Food Safety Modernization Act, or FSMA, which I'm going to move into my talk, a portion of my talk on food safety, by focusing on that. And I could give a 2-hour lecture on FSMA. By a show of hands, does anyone want that? No, yeah, me neither. Food safety and sustainable food practices are often at odds. This was a great example, and I mean, there's the, first of all, the FDA has absolutely zero expertise in the area of agriculture. So why they're making rules that pertain to it is mystified beyond the idea that they obviously want to sort of maximize their budget, their power. And the brewery, proposed brewery regulations, which said that spent food grains could no longer be used to feed farm animals, which was an early proposal of FSMA, which the FDA backed down on after being called out. That is a good example of that. There's the other provisions that would have put many small farmers out of business by, for example, essentially banning manure, which is pretty important for raising organic crops, as I know from raising organic crops in my victory garden. These were provisions in FSMA that just made absolutely no sense. Thankfully, lots of farmers fought back, and there are new rules. And I should note, I guess, that the 2 key rules, there's one for good manufacturing practices, another for produce rules. By the FDA's own estimates, will make our food somewhere between 0 and 4% safer. So it's a lot of expense, a lot of buck, but not much bang. Anyway, so that's one example of food safety rules that simply are bucking sustainable practices. There's also farmers market rules. It was about 2.5 years ago, I guess, my group worked with Harvard Law School's Food Law and Policy Clinic, which is a great organization committed to work, on a report on state farmers market regulations. They looked at for us 10 different farmers market regulations at the state level around the country. We were concerned that a new set of rules, Pennsylvania would enact some ridiculous requirements. At least that's what we heard from some of our supporters and members in Pennsylvania. So essentially the fear was that it would enact a series of process-related regulations rather than outcome-related ones. So picture the Amish farmer who has to suddenly have a refrigerated truck to keep his milk or eggs cool. I think you understand that that would be a bit of an issue. Rather than say that to the Amish farmer, get a thermometer and make sure that your eggs and milk are below 40 degrees, use ice, use whatever you want to, telling them and everyone else in the state to have that, and also to have, I believe, the regulations as proposed, so that every single vendor at a farmer's market had to have their own hand washing sink and their own portable toilet. It would have imposed costs that would have essentially driven everyone out of business. Luckily, that was not the case, but the Harvard report did find that there are states that have such rules and recommended sort of model regulations. So these do work. There's a glove law. Is anyone familiar with the California glove law that was passed last year? Thanks to a furious backlash, was repealed. So chefs in California and bartenders were told that they had to wear gloves to prepare food. It's not really the best way. In fact, if you make sushi, you literally cannot make a sushi roll with gloves. And it was going to force them to essentially change their gloves every 5 minutes because it makes your hands sweaty, it kills your dexterity, not to mention the food waste issue, which I'm going to talk about more. But chefs were so up in arms in the state there that they pushed back against that as a dumb food safety law. So those are a couple examples. And then these local laws, there's a guy, sustainable lobster roll salesman, who was put out of business because of regulations. And some of you, even those of you the sort of more libertarian bents who might be in the crowd, might in fact think that this guy should go out of business. He used to dress up like a cross between pretty much any sort of Ben Affleck character in a Boston themed movie, which is pretty much any Ben Affleck character, and Ali G. And he would wear gold chains with a lobster on it. And he would make lobster rolls using propane tanks in his kitchen in Brooklyn. And he had a system where you would ask him for a lobster roll on Facebook, we would meet in the corner, and he would pull up in a Trans Am. It was great performance art with the fire department and health regulators in New York City. Anyways, I mean, his dad was I think his grandfather had been the fisheries commissioner in Massachusetts. He'd grown up in the sea. He only used sustainable food. I mean, it's a question, I guess, a legitimate one, whether this guy should have been in business or not. But either way, he was a sustainable business put out of business. And I'm sure you all read this article, the Save the Icelandic Goat from Extinction. I'll just refresh your memory in case not. So this was last year, and a woman in Iceland who'd been a nurse learned about these goats in Iceland, and I think there were only something like 82 of them left. They were bordering on extinction. So she thought, well, darn, I could capture a few, make a farm, and I could actually raise them and sell their milk and use that money to help reintegrate the species. And I guess they were brought to the island by Vikings 1,000 years ago. They were unique species. And that was great, except that Iceland told her that she couldn't sell raw milk, and that therefore, she had to destroy her goats. Thankfully, there was again a backlash, and an Indiegogo campaign, which is a small fundraising tool, which helped her save the goats from extinction. And now there's something like 800 goats in that. But anyway, so these are regulations, food safety regulations that really aren't making anyone safer and are frankly hurting small business men and women, and hindering the number and quality of food choices that we have. So on to food waste. The National School Lunch Program is sort of food waste exhibit 1. The notoriously conservative editorial page of the LA Times 3 months ago or something like that blasted the Obama administration for the school lunch program, saying that it was wasting incredible amounts of food. I don't know what the percentage of food that's wasted thanks to the school lunch program is, but as Americans and as society in general, we all waste something like 40% of our food. And I think the National School Lunch Program, if I had to guess, pretty much wastes all of its fruit and untold amounts of other food. And the general premise is, of course, that the federal government is, and no one would say this, of course, but they're sort of foisting subsidized foods on school children that are produced to excess. And if you look at the school lunch program and the foods that they serve right now, they're exactly the same foods they were serving 5 years ago, 20 years ago. There might be a little more whole grain chicken nugget. The hot dog one might be made from whole grain. Pizza contains some whole grain, but otherwise it's essentially the same thing. The food, I think I can easily bag up Republicans who were saying, no, let's go back to the way things were 2 years ago or 3 years ago. The school ed program wasn't good then either. So I think that the waste that this program promotes is ridiculous. And I think I proposed a program called Opt Out of School Lunch, where solutions can be made at the local level. So if you have a restaurant community, you have a partner up with the school, and students who are receiving free or reduced price school lunches could receive food from that restaurant. You can have a variety of restaurants partner up. They can make sandwiches. It's an inexpensive way to provide quality food to students, and it also reduces food waste rather than promotes it by making sure that the restaurant doesn't throw out its chicken breast. So anyways, I think it's a win-win, and it doesn't cost anything. Whereas the school lunch program costs billions. There are other rules that promote food waste. Shark fin bans I'll talk about. I'm actually a fan of the federal shark fin ban, and I think state shark fin bans, for lack of a better word, stupid, but I'll explain that a bit more. Horse slaughter, I missed the morning session. Did anyone talk about horse slaughter? No. All right, so yay horse slaughter. Yay horse meat people want to eat. So there was a federal ban on horse slaughter. That ban was lifted, although the USDA has yet to issue a last check permit to any of the applicants to open a slaughterhouse. I think there were at least 2 in New Mexico a year ago who wanted to slaughter horses, and you couldn't because the USDA, which was supposed to issue permits, hadn't. So there's a problem around this country of people who normally would have sold their horse for food once it's reached sort of the end of its utility on the farm. But they can't because you can't kill a horse at the slaughterhouse. And so what you have are these horses running around and starving to death all over the country. I think that, as you said, I don't think anyone thinks that's good. I think it's unfair to the horse, to the farmer. It's their property. They should be able to alienate it from themselves if they'd like to. And frankly, there's a demand for horse meat. The horses just end up getting sent to Mexico. We're told that the conditions there are terrible in slaughterhouses. I don't know. I haven't been to one. So anyways, there should be slaughterhouses for horses if that's what consumers want. And then roadkill and foie gras, I can answer questions if you have those. But I like the sort of juxtaposition of the two. They're seemingly nothing like each other. And then, I guess joking aside, the bans on sharing food with the homeless and less fortunate, I think it's probably the most detestable food laws that I see around this country. I had people in Orlando with a group called Food Not Bombs arrested for providing food to the homeless and less fortunate. People in Philadelphia, the same way. The ACLU was sued, got that ban pushed back. And there are plenty of other places. I spoke at Duke a couple weeks ago, and I think it was Raleigh who also had a ban in place and was threatening to arrest people. There's absolutely no justification for this. If there's litter or some other attendant problems, then fine people for litter. But the idea that some group, religious or not, or whatever motives, that has extra food, that wants to share with people in need, it's despicable to the government at any level. I think unconstitutional would do this. And internationally, I was in Portugal over the summer, and I visited with a woman from a group called Fruta Feia, lovely fruit in Portuguese, and they're trying to get more misshapen, uglier fruit that perhaps wouldn't pass sort of a rating system to consumers. There's the economy in Portugal and Spain is pretty lousy. This group is trying to match up farmers with consumers. They have sort of the CSA. And I think the analog here would be USDA egg rating. When I had breakfast this morning at the Lexington diner, it said right on the menu, all of our eggs are grade A. I don't care what the egg looks like, and I want it to taste good. But for it to have a uniform size and shape is not terribly important to me. I actually prefer to buy right, so two words that are two phrases that you don't often see next to each other. One, big government. Conservatives, I think, are big, and maybe some libertarians too, love to use that term. And then big food. Lots of sort of liberal, progressive foodies refer to Coca-Cola, Pepsi, McDonald's, etc. as big food. So these are sort of buzzwords on the right and the left, respectively. But not so surprisingly, they often work together to sort of shape our food choices. And I don't have time to go through all these, but farm subsidies are a great example. Tariffs that support the sugar industry is another great example. Commodity programs that essentially support the growing of particular crops, but not of others, at the federal level. USDA organic labeling, another program that organic labeling had a lot of meaning at the state level when it started. California certified organic farmers, Oregon Tilth, back in the early 70s. There was a lot of meaning in that label, and that's pretty much been lost thanks to USDA taking over, redefining it. Standards of identity such as the grade A egg, but also FDA labels. GMO subsidies, what do I mean by that? Well, corn, something like 90% of the corn, at least as part of this country, is GMO, and GMO corn is probably the most subsidized crop in this country. GMO soy is the same thing. There's the Monsanto Protection Act, something like this. So this is something that was snuck in by Congress. Controversially, last year, it was, I think, only in place for 6 months, but it essentially would have sort of ordered Secretary Bill Sack, even if there was a lawsuit challenging some GMO crop as harmful, it ordered Secretary Bill Sack essentially ignore that. Ignore a federal judge who tells you that you should get this off the market. And I should be upfront that I'm entirely different, agnostic when it comes to GMOs, but I think the government should be promoting them, shouldn't be restricting them, and should be taking that off the bridge. And then the most nefarious thing that if some of you have heard about the proposals for a unitary food safety agency, so would essentially wrest the food safety functions of the FDA and the USDA from those agencies and form a sort of super agency under the Department of Health and Human Services that would regulate all food safety. Well, written in there are actually federal regulations, or the potential for federal regulations of local restaurants, which would essentially be the end of local restaurants, I think. So keep your eyes on that one. And then state ag-gag laws. Any of you familiar with ag-gag? So anyways, it's these laws, which I think there are about 5 around the country. I don't know if Kentucky's one of the states or not. The laws invariably say something along the lines of you can't take pictures of farm animals. And if you do, then you have to turn them over to authorities within 24 hours. It's essentially a way of getting groups like PETA and the Humane Society and other animal rights and animal welfare groups from doing undercover operations in slaughterhouses and on farms and things like that. And I don't love PETA. I have no love for PETA. But their First Amendment rights are exactly the same as mine and yours. These laws absolutely are just about protecting big agricultural producers. And so it's another way that the little guy is essentially who is spending more money on producing, raising humane livestock. Their actions are not being reported by the government that tells them that what they're doing is not worth anything because they're banning all photography. So again, back to I say tomato, you say no. This is about the people's interest in raising, obtaining, growing their own food. Hemp, which I think there's something in Kentucky is actually at this university. There's been a ban on growing hemp in this country. That hasn't stopped any of you from eating your hemp waffles in the morning if you want. So you can grow it in Canada, grow it elsewhere. Hemp is, as I would suspect everyone knows, is essentially a cousin of cannabis, or it might even be cannabis, but it doesn't contain any THC, which is the psychoactive ingredient. And it makes for good food and other things, fiber, whatnot. So you can't grow it in this country, and there's a Senator Paul actually from Kentucky proposed rider, I think, to perhaps the Farm Bill. It's not great. And it passed, and it says that for experimental purposes, colleges and universities can apply to grow hemp. Well, that's certainly, it's a step in the right direction. But hemp is a crop like any other. You should be allowed to grow it, and it's it's called weed for a reason. It grows very well on its own. It doesn't need much inputs. I don't think any pesticides are required to grow hemp or its cousin. And so it would actually make a huge difference in terms of the food and fiber that we obtain. Wild food, another good example of things that the federal government won't let you do. If you hunt that elk on federal lands and then you try to sell the meat, either to your local butcher or to your neighbor, those same federal people who let you hunt on the land will come and arrest you because you're not allowed to sell wild food. Cottage food laws are sometimes overly strict. There are ones that say you can sell a certain, this is awkward wording, but non-potentially hazardous food that you produce in your own home, usually something that's not like a custard or meat, but is something like popcorn that you made at home. And there are, I think, in at least 40, maybe 45 states by now. But some states say that you can only earn $5,000 a year. I think Minnesota as well. So it almost sort of neuters the laws. And then there are your home gardens. I think from coast to coast are under attack. There's a lawsuit, the Institute for Justice, which is a libertarian law firm in the DC area, is suing on behalf of a couple of Miami Gardens, Florida, near where I used to live, who made a mistake to grow some produce in their yard, cucumbers and tomatoes and things like that. And in Massachusetts, near where I also used to live, there was a guy who had his tomato plants ripped out of his front yard. And other people have had the same thing, like literally government agents coming out of their property and ripping out their vegetable garden, which was just for a variety of reasons horrifying. There's also, since we did focus a little bit on water, I'll address this one. There's a woman in Florida who decided that she was opting out of her town's water supply. She was somehow getting her own water. I have no idea how. Maybe she had a well. Maybe she went to Publix and bought a lot of water. I have no idea. But in any case, the city actually ordered her to use their water and said that she couldn't opt out. And I guess internationally, I should note, I was at a conference earlier this year and I saw a woman, First Nation, which is the equivalent, Canadian equivalent of Native American, woman who was talking about how Canadian sealing regulations harm her community. That's sort of their number one food source. Now they're forced to rely on Nabisco products in the grocery store. So she showed them all the things that they use the seal for. They make knives and hair braiding thing. I mean, it's they use all of the seal. They end up using all of the seal to make everything, and they're essentially banned from doing it. So that's the dark picture I painted. But yay, federal shark fin law. All right, so essentially the federal shark fin law says that you can't fin a shark. So you can't cut the fin off a shark and just let its body kind of sink down to the bottom of the ocean. And I'm not a hunter, but I think that's pretty consistent with general hunting rules that say if you kill a deer, you can't cut off the buck's head and leave the carcass in the woods. You have to gut it and bring it out. And there's been some there, so if you want to. Well, the federal shark fin law is the equivalent of that. State shark fin laws say that you actually have to fin the shark because you can't bring the fin back to Maryland or California. So, I think they're probably preempted. And I don't know that anyone's actually challenged any of the laws on those grounds. But from a sustainability perspective, saying that you have to bring the whole shark back and you can actually sell the fin, you can make soup out of it, but you can use the rest of the shark for whatever purposes you might have, I think makes a good amount of sense. Quickly, cottage food laws, obviously there's some good ones. Most states actually have pretty good ones. California has a good one that could use some improvement. They only allow you to sell enumerated food So if it's not on their list, I don't know, like kale chips, for example, not going to kill anyone, not on their list, we can't sell it. Good Samaritan laws, which allow people to donate food to the homeless. Essentially, it's a federal model legislation that's been set up that many states have adopted. And food freedom laws, which have not actually been adopted yet. There's a state rep in Wyoming who sponsored one, didn't go anywhere, that may have a chance of revival in Virginia, actually passed or considered a food freedom law too. These would essentially allow commerce between neighboring farmers and local communities. So if you want to make some pasta out of your eggs and sell them to your neighbor, then agents of the government aren't going to swoop in and arrest you. Food sovereignty laws, which are largely a Maine MAINE thing, are more aspirational than anything else, but I think they're a good idea. So how do we get more sustainability and fewer rules going forward? Well, we do that. Foster the good rules, eliminate the bad ones, and I don't think there's anyone in here on any topic who doesn't want more good rules and fewer bad rules. We all agree that we might not agree on what those are. So the solutions are to eliminate the bad ones and promote the good ones, and then keep in place some of the ones like those that protect endangered species, for example. And then, this is not a purely academic exercise. So there are my own group, there's the Local Food Association, which is a new group that is based here in Kentucky, actually, that's promoting this sort of thing. The Farm to Consumer Legal Defense Fund, and the Institute for Justice, which I mentioned before, which has a food freedom project. The Harvard Food Law and Policy Clinic is one of many clinics around the country. I think I wrote an article with the head of the clinic, and we identified something like 50 to 100 clinics around the country that have focused on at least some food-related work, which I think is spectacular. They're transactional clinics, on a variety of issues. This does have some bipartisan feel, and again, I'll note the Kentucky connection. Representative Thomas Massey and Representative Shelley Pingree are both members of Congress in D.C. and sponsored a food freedom bill earlier this year on raw milk. And interestingly, perhaps not coincidentally, they're both farmers, both organic farmers and have been for a long time. And there are state and local efforts around the country that can help ensure a more sustainable food future. So just quick conclusions here. Government shouldn't be picking winners and losers. There's a big market for sustainable food. I think it will grow, particularly if regulators let it. And so that's the best way. Questions?
Why is the National School Lunch Program so bad in terms of because they're serving bad food?
Yeah, good question. Why is the school lunch program so bad? I mean, I think that how many people in the room are parents? I'm not a parent, but how many parents do we have here? And I bet if I say like peanut butter and jelly sandwich, maybe 3 of you will be like, oh yeah, Stevie or Susan loves that. And 2 of you will be like, no, they hate that. The government can't choose with that level of specificity what kids will like, and unfortunately, all kids like junk food. So that's really where the sort of agreement is. They need at the lowest possible denominator. And I think that it's incumbent upon parents who don't support the kind of food that their kids are receiving in school to actually make them lunch, or make themselves lunch. That's what my parents did.
I think there are a lot of kids that wouldn't otherwise be home.
That's right. Right. Yeah, that's I absolutely agree. And I mentioned about the opt-out of school lunch program, the purpose of which is to reduce restaurant food waste and also give those kids actually a much better deal than they would have gotten in school otherwise. But yeah, that's an important problem. It's address it. Yes.
Speaking of kids, what's the consistent way to think about food versus bad rules when the people consuming food like that be the ones choosing? You could use the example of raw milk or anything that's potentially.
Yeah, raw milk is a great example of that. I'm opposed to any raw milk ban, but I think that warning labels are absolutely sensible kids are eating steak tartare, which also can sicken. But as we've seen from I think the most recent food outbreaks have been things like cantaloupe and spinach and other things that are, I don't think there's no real argument that spinach isn't healthy, and yet these foods are the ones that are often sickening us. So I think that education, wash your fruits and vegetables or cook them, wash your hands. Washing your hands can eliminate more foodborne illness than the FDA. If everyone in this room wash their hands after touching the door as we exit this room, then we'll have a good next week. And if you don't, then I really can't vouch for your future. Yes.
I work with producer groups in agriculture and we meet with dairy guys and plays. They're totally opposed to school lunch program. Their aim is shaping kids' choices in what they consume in the milk industry because you cannot have 2% or whole milk now that's only skim milk and go home and mom and dad don't buy stuff. It's disgusting. But that's what they have. It's associated with milk water. They don't drink it at home. So there is an incentive from a producer standpoint that the school lunch reforms are helping shape to make positive or negative consumer choices.
Yeah, I think that's one example where it's incumbent upon parents to send their kid to school with the milk that they want their kid to drink rather than relying on the government to give them the milk that they don't want. Which is not to say that what the government is doing, the school lunch program is good, but parents can, they have a lot of power. And I don't know that there's a right answer to which milk should be served in school, because I certainly don't have it. Is it skim? Is it 2%? Is it whole? Is it chocolate? Is it heavy whipping cream? I mean, I don't know. But I don't think that, I think that as a parent, you would know better for your kids certainly than I would, and absolutely better than an agency of large size in Washington. Other questions?
Thanks, Mr. Lincoln. And our last speaker is going to be Alan Olson, talking about agricultural law and the Farm Bill and things like that. Thanks.
Great. Thank you. I tell you, all of them are very patient, quiet, thoughtful audience, and as a reward, I'm going to promise you one to be fairly short because I've got a plane to catch. But secondly, I'm going to show you a lot of good pictures. I think agriculture and pictures have to go together because otherwise we risk a major disconnect between food, which is made in the back of the grocery store, and the farms that produce it. Now, before I go on, I do want to thank the Journal, the Law School, and Dylan, who I guess is outside, for getting me here, putting me up, and feeding me well. Even if the weather was a little chilly. It was 77 Sunday in Albany, Georgia, where I spend most of my time. I sort of split my time. I'm mainly a law practitioner. All of my clients are farmers, and mainly in Georgia, some elsewhere. But I also teach at the University of Arkansas Law School in the graduate LLM program for agricultural and food law. And I want to make, before I go on, a little plug for our program. Balin is a distinguished graduate of it, as am I. And for those law students here who might think that 3 years of law school is not enough, I urge you to go online and check out the LLM in agricultural and food law and maybe consider it. I think it'd be worth your time. I I've got to get a new picture. That is a very old technology cotton picker. The new ones cost about $800,000 and wrap it up into a nice round bale. I came here because it's a good place and a topic, but I also came here because I have some equines. And one of my equines, named Perry, was so excited to hear that I was going to appear at an equine law conference in Kentucky, of all places, that he wanted me to give him due mention. And there's Perry. Perry's my pack donkey, and the early odds makers have him favored for the Derby this year. Okay, I'm going to talk mainly about the Farm Bill, or at least part of it. The Farm Bill is voluminous. It's been around for a long time. It goes through various evolutions and maybe revolutions. It's got a lot of problems, but it's been a major fixture in a lot of people's lives, particularly in rural America, and now more than ever elsewhere. We got our first farm bills in the 1930s as a direct response to the Great Depression and the Dust Bowl. And since that time, U.S. agriculture has received substantial government subsidies. Big dollars at some times. But some sectors of U.S. agriculture have received and do currently receive a lot more than others. Typically, the subsidized commodities are row crops: corn, soybeans, cotton, peanuts, rice, and generally not vegetables and not livestock. Although one might argue quite a few farm bills ago that farm bills may have worked to keep crop prices low, feed grains low, and thus provided an indirect subsidy for livestock. Then ethanol came along, and the farm bills changed, and arguably that's not the case as like it used to be. Vegetables have started showing up in the last couple of farm bills. Much of it has been promotional and research-oriented as opposed to a direct subsidy, but there is more recognition of their importance than there used to be. Subsidies are provided through legislation that's pretty universally known as a farm bill. The current farm bill was just passed last spring. It is called the Agricultural Act of 2014. It expires at the end of 2018. Farm bills typically last for 5 or 6 years, although they tend to be extended a year or two because Congress has had a real problem in recent years getting them done. They're an excellent example of the golden rule. That is, he who has the gold makes the rules. There are a lot of rules that farmers must comply with to obtain whatever subsidies might be applicable. Peanuts in South Georgia, our second biggest crop after cotton. First farm bill was enacted in 1936, subsequently declared unconstitutional. But then the Agricultural Acts of 1938 and 1949 became the foundation for modern farm programs. And some of you may know this, but these two acts, the 38 and 49 acts, are our permanent farm legislation. If Congress fails to pass a new farm bill at the expiration of a current farm bill, these two acts go back into effect. And that happened for a better part of a year when the 08 farm bill expired before the passage of the 14 bill. Now, it's somewhat ludicrous because the entire farm economy upon which the 38 and 49 bills were based doesn't exist anymore. But for some reason, Congress won't repeal these statutes. I think the feeling is if you have the possibility of chaos resulting from these going back into effect, that will put pressure on Congress to ultimately enact a new farm bill. And then the 38, this is our second reference to Wickard v. Filbert. It's got some major constitutional significance. I never thought the wheat grower there was quite as innocent as everybody thought. But clearly the constitutional basis for farm subsidies and restrictions that accompany their receipt was established in that case. Now, also in another 1936 act, we saw the first conditioning of farm program subsidies on soil conservation compliance, undertaking various management techniques to keep soils from eroding by water and wind, a major problem then and arguably still a problem now. And then in 1938, we got the first crop insurance program, and crop insurance has been with us ever since. Okay, let's talk about some of the basics of the 2014 Farm Bill. Just as an aside, this Farm Bill might not have happened. The coalition in Congress that normally enacts farm bills almost fractured completely. And took 3.5 years for Congress to come up with this. And quite frankly, it's pretty sloppy. But sloppiness is good for my business because I represent farmers who try to maximize their payments that they receive under whatever farm bills might be out there, under whatever programs. And I'll tell you, unless you're willing to sit around and read boring regulations for a long time, this farm bill has become difficult to understand. Shows you I probably need to get a life. But here are some of the what we have. These are the numbers. 2014 through 2018, we have about $1 trillion authorized. This is not insignificant legislation. Of that total, 44.5 billion are for direct farm subsidy commodity programs. 89 billion for crop insurance subsidies. I believe this is the first farm bill in which the subsidy for crop insurance exceeded the subsidy for direct Title I programs. 57.6 billion for conservation programs. I think that's down a little, but that's still a fairly small amount out of 1 trillion. The rest of that 1 trillion goes for a lot of other things that come under this umbrella piece of legislation. One of the biggest big food stamps, and the Women's, Infants, and Children's program. There's also a lot of money for research and education. University of Kentucky and a lot of other schools get big chunks of money for things they do. Again, under the Farm Bill. There's the site for you if you want to read it. I'll tell you, I've actually got a couple of clients who make it a point to read the entire Farm Bill, which is better than I can do. But they find things there that are hidden away, little gems from their standpoint, because it's a great place to sneak things into. A few years ago, a state legislator in Texas managed to get passed by the General Assembly a bill commending Jack the Ripper for his efforts in population control. That sort of thing could happen in the Farm Bill. It is so massive. Okay, there are a total of 13 titles, 12, sorry. The ones that I focus my practice on, and the ones that are of most interest to farmers, are the Title I commodities, the direct subsidies, Title II, the conservation programs, which can pay significant amounts of money for undertaking certain practices, and increasingly Title XI crop insurance. More information there for you at that website about the whole Farm Bill, and this PowerPoint's going to be made available if anybody wants to get that information. Okay, here's what we have on the Title I commodity programs. One thing we kept, which we've had for many, many years, is the commodity loan program and marketing loan gains and loan deficiency payments that go along with it. I think this is a pretty important program historically because crops are harvested pretty much at the same time. A little difference between north and south, but in the fall, you've got this tremendous production of all sorts of commodities. Well, if all of those commodities were to go on the market at the same time, obviously that would depress the price dramatically for some time. For the covered commodities, and that's not everything, but the major row crops, a farmer can put the commodity into a 9-month government loan and receive a payment on each bushel or ton of the commodity tied to the loan rate under the Farm Bill. The loan rate for corn, for example, is $1.95. It's $535 for a ton of peanuts. It's a non-recourse loan. And the hope is that after 9 months, or before then, the market price is above the loan rate, at which point the farmer sells the crop, pays back the loan, and you've spread out this production over a longer period of time. However, if prices are below this loan rate, we've not been there for quite a few years now, the farmer can forfeit that crop to the government and not have to pay back the loan. Well, during the 80s, that created a tremendous surplus of crops at government storage. So the government then added a provision that allowed you to pay back the loan, not at the world price, lower than the loan rate, and clear the market without the necessity of forfeiting it. Again, there's a lot of detail to this, but that's probably one of the most important programs that's continued. And then we have two brand new programs, the agriculture risk coverage and price loss coverage programs for major commodities, except cotton. Many of you may know that cotton was the subject of WTO litigation by Brazil, which Brazil won. And as a result of that suit, for quite a number of years, the United States was basically paying reparations to Brazil to keep them from imposing countervailing duties and tariffs on other U.S. goods. Well, as a result of all of that, cotton does not participate in either the ARC or PLC programs, and we will see whether Brazil is mollified by that or whether those issues go on. Agriculture risk coverage payments are made in any year that actual crop revenue for the crop is less than the agricultural risk guarantee for the crop. It's a complicated formula, but it basically looks at two factors: declines in yield and declines in price versus standards. And price times yield is by definition revenue. ARC is likely what most corn and soybean producers will be selecting, particularly in the Midwest. You get to choose under this Farm Bill between ARC and PLC crop by crop. You do it at the beginning, and it's a permanent election. As I tell my clients, how good are you at predicting what the farm prices and economy are going to look like in 16, 17, and 18? No one feels real comfortable on that. Nevertheless, you have to choose. Price loss coverage is like the old target price, in which payments are made when the price for the crop drops below its reference price. Corn at $3.70 a bushel, wheat at $5.50, and soybeans at $8.40. Again, those are the two major programs that are out there now, or three rather, on the commodity side. And then we have crop insurance. 2014, Farm Bill retained the federal crop insurance program and mandated some new types of crop insurance, including stacks for cotton, supplemental coverage option for any crop in which a PLC election is made, a peanut revenue policy, and some changes to enterprise coverage. The thing I want you to take from this, though, is that crop insurance is highly subsidized. USDA pays a substantial portion of each crop insurance premium paid by a farmer, of each indemnity paid on claims, and a certain portion of the administrative expenses of the private insurance companies that sell these policies. The feeling has always been, I think it's been true, that without these subsidies, there wouldn't be much crop insurance out there. The question is, ultimately, if you get enough participation, could these programs become self-sustaining? I don't know the answer to that. We're certainly not there yet. Okay, conservation programs. Most of you have heard about CRP, the Conservation Reserve Program. It pays landowners to conserve an idle farmland by putting land into native grasses or, in the South, in longleaf pines under a long-term contract. A lot of land has been protected by CRP. It's usually a 15-year contract. As long as the land is in the program, it's got to stay in grass or pines. There's a fairly new program from the last two farm bills, Conservation Stewardship Program, that pays farmers to adopt and implement specified conservation practices on farmland and forest land on a 5-year contract. At $40,000 per person or $80,000 for a joint venture, up to those amounts. There are a number of other conservation programs, including EQIP and easement programs. Okay, here's the regulation part of this. In theory, you don't get this money for nothing. There are governmental objectives, societal objectives that are met in addition to the purpose of subsidizing farms. Receipt of most farm subsidies, including the ones we've talked about, is conditioned on compliance with a number of things, but these are the three major ones. Highly erodible land conservation, wetlands conservation, and farmland conversion restrictions. The highly erodible land conservation provisions generally apply on erodible land out west where wind is a factor, although that, in theory, they apply everywhere. And essentially, you can't grow an agricultural commodity on highly erodible land unless it's being farmed in accordance with the conservation plan approved by NRCS. This all began with the Food Security Act in 1985. And the problem that it was addressing then was the plowing up of virgin grasslands on the high plains to respond to commodity prices and demand. And it started some mini dust bowls. And so this is one of the provisions that was enacted at that time. Wetlands conservation probably has been an effect on more farmers than the AGLC. And there are three basic rules there. The farmer may not, if they want to collect subsidies, they may not plant or produce a commodity on a wetland that was converted after December 23rd, 1985. The farmer must also not have converted a wetland after November 1990 for the purpose or to have the effect of making the production of an agricultural commodity possible on such converted wetland. Or third, the farmer can't convert a wetland by draining, dredging, filling, leveling, removing woody vegetation, or any other activity that results in impairing water flow. The again, allow the planting of an agricultural commodity. These are the requirements in 7 CFR Part 12 that you've got to meet if you're to collect the subsidy. Now, if you're not collecting subsidies, some of those things might also get you in trouble with EPA or the Corps of Engineers. That's a big issue now with the new EPA rule. But in this context, the violation of these rules is going to render you ineligible for subsidies, both on the highly erodible and the wetlands. That's a map showing the change in percent of urban and built-up land. Farmland conversion in this country has covered a lot of acres. You don't have to go too far outside of Lexington to see examples of that. This provision, 1118 of the 2014 Act, would deny subsidies to the extent farmland is converted to non-agricultural, commercial, industrial, or residential uses. That would seem to make sense, but without that provision, it might be possible to build a subdivision and still collect payments related to the base. I'm sure it's happened. Now, to collect these payments that we've talked about, farmers must sign a producer agreement, agreeing to comply with the farmland conversion restriction, HELC, and the wetlands requirements. They must also agree to control noxious weeds. I'm not sure how much that's enforced in the absence of neighbor complaints, but it's in there. Okay, told you this is running fast, but I want to talk about, that gives you a very quick, very rough basis of what's in the current Farm Bill. And we've had these Farm Bills continuously since the 30s. The provisions have varied, although they've frequently taken the same approach. They've provided subsidies with restrictions. Some of the restrictions relate to conservation. Some in the past have related to restricting the amount of production. We typically don't use those now. In recent years, I think the general public has become more aware of farm bills and has started questioning whether the subsidies are a good thing or not. And certainly they're questioning where the subsidies are going. Should they be going to somebody else? And there have been some changes made in that regard. But I suspect there's going to be a lot more change made in the future, or perhaps we're not going to have a farm. There's an editorial in the LA Times during the Farm Bill debate that suggested that this would be the last Farm Bill, and that in the future we might have 10, 11 separate pieces of legislation separately addressing these various topics. Quite frankly, it almost happened. I mentioned the coalition that has enacted farm bills. Well, it's a coalition of farm state representatives in Congress and inner city representatives in Congress. The compromise, farm bill after farm bill, has been, if you vote for my farm subsidies, I'll vote for your social welfare programs. Food stamps for subsidies. And that has been the coalition that has enacted farm bills now since late 70s, early 80s. Almost fractured. We came very close to having a separate food stamp bill and a separate subsidy bill. And interestingly, some of the most vocal opponents to the separation of those two subject matters in the legislation were traditional farm groups, because they realized that as a separate piece of legislation, they were going to get a lot less than they would get continuing to be linked to the food stamp program. food stamp program wasn't going away. It got reduced a bit. But the farm subsidy program, I also have to look at the context in which this last farm bill debate occurred. Some of them, it was generally some of the most productive, profitable years in American agriculture. I really was surprised that we ended up with ARC and PLC. There was some, and I think there's certainly a possibility that in 19 or 20, when we get the next farm bill, we may be looking at crop insurance as the only major farm program. The Title I subsidies may largely go away. Generally, my predictions are wrong. And farm bills are clearly, as somebody said, I didn't invent this, they're evolutionary, not revolutionary, but there's a movement in that direction. So, I mean, to finish up here, what might be the future of farm bills? Do we need them? And that brings us to the basic question, why do we subsidize agriculture? And also, what about the other parts of the farm bill? Nutrition, food security, food safety, research. Can one piece of legislation cover these, or should different areas have their own legislation? Well, I'm not going to answer that question. That's for you to debate. But I will point out that most countries give agriculture special treatment. And they do it for a variety of reasons. Some good, maybe some not so good, but food security is always cited as a reason. You know, the European Union countries have generally much more extensive farm programs and restrictions than we do. And food security is always cited there as a reason. And I think here, preservation of landscapes. Most people prefer looking at farms to urban sprawl. And when you preserve agriculture in a particular area, you're preserving those landscapes. You couldn't be talking about that issue in a better place than Lexington. There are also cultural and demographic reasons that people want agriculture treated. Or, as my colleague said, there's rent seekers. People who get them want to continue to get them. My clients are certainly guilty of that. Although I've got to say, and I never apologize for anybody getting a subsidy. If it's out there, and you don't take the steps to collect it, your neighbor will. And if you can do it legally, you should. And that's the point at which I generally see these farm bills. But, and I want to also mention to you the Jeffersonian yeoman farmer. Have any of you heard Jefferson's pronouncements at first? And he thought generally they were the backbone of American society and preferable to all other classes and occupations. They were better than carpenters and industrial owners, not that we had many back then, and merchants. The farmers were to be the bedrock of our society, and he referred to them as the virtuous yeoman farmer. Well, there has not been a farm bill debate since the 30s in which at some point a representative or senator has taken the floor and spoken of Jefferson's virtuous yeoman farmer as a reason to pass a farm bill. And there's something in the American psyche that hasn't minded farmers being treated differently. I will also mention, though, that people go after farm subsidies. Most of them forget that there are very few of us in this country who don't get a subsidy one way or the other. Tax breaks, scholarships, certainly the social welfare programs. And of course, what I find is my clients, probably everybody else's, no one else should get a subsidy but me. We had an old farmer out of Baker County, Georgia, who was before my time, and he'd show up at parties in Albany, and he'd get a snoot full of bourbon. He would give these flowery orations, and one of them, he said that there are only two legitimate constitutional functions of the federal government. One was the common defense, the other was the peanut program. And that's how people are. You know, if they're going to some maybe more specific reasons why farm programs of some type may be necessary, is that the production of crops and livestock is inherently risky. The biggest risk is weather, and next is market volatility. You know, there's a concept that the ag economists use of asset fixity. Well, you know, once you've invested all of this equipment to, you know, peanuts, for example. Peanut equipment only works on peanuts, cotton equipment. It's hard to replace all that equipment and quickly move from one crop to another. Of course, we have the natural crop cycle. If you've got your crop in the spring, whatever it is, and those prices change dramatically, and that's what we saw happen last year. You're not that nimble. You know, you can't quickly move resources into something else. Also, your land is there. And it may not grow everything. It grows certain things. You just can't switch around. So I think those are some of the reasons behind having subsidies and a safety net. Yeah, and quite frankly, over time, I think we've also had a policy in this country for lower food prices. There were several points in the history of farm programs where we could have opted to go the other way. You know, maybe that's not the reason now. I'm not sure. We talked about the coalition and how it fractured. But here's where I'd want to leave you. And I'm certainly as much of a critic of parts of the Farm Bill and how it's done as most people. In fact, I only give these speeches outside of South Georgia. Although most of my clients like me, they'd forgive me as long as I get to their pay. But I do think if it could be done well, it does make sense to look at agricultural production, food safety and security conservation, in a package, because it's all related. And the question, you know, we'll always have a debate what those rules should be, but I don't think those rules should necessarily be considered in the abstract. We don't want food to be what's made in the back of the grocery store. Okay, now, if you probably noticed at the beginning of this section, there was a picture of belching smokestacks. I thought maybe if I showed that in Kentucky, I might be shot. But the future for the world, but certainly for agriculture, is going to be more risky, not less, with climate change. Whatever, there are a lot of things one might debate about the rate of climate change, whether you might slow it down, and what areas will be affected the most. But the general consensus is it's going to happen to some degree, and long term, agriculture is going to bear the brunt. Now, initially, there may be some areas that a little more CO2, a little more rain may do better, but long term, globally, it's going to make agriculture trickier. And so I just want to leave you with the thought that perhaps a future farm bill could be one of the mechanisms for helping farmers manage that risk and adapting to changing conditions. And that in turn might help protect food supplies and prevent some level of social unrest. For that, what that would involve is what we have now on a grander scale, which is laws that deal with the allocation of resources. And the subsidies, including the risk management subsidies, that could be provided, like we do now with crop insurance. You're going to have some restrictions tied to it, you know, that keep farmers from doing things that will make the situation worse. So anyway, thought for the future. It's not where we're there now. But in a sense, the Farm Bill, in an imperfect way, is one of our few national land use statutes. And it's something people are used to, and they fight over it, but it has a level of acceptance that a new statute might not have. It might be a good way to slowly build on these issues. Well, Perry says thank you for inviting him to the Equine conference. And there's my contact information. I'm always happy to talk to people about this. Happy to take questions. Yes, sir.
Question for you. One of the places where farm production and energy mix is in the use of corn ethanol.
Yeah.
And I'm wondering, a few years ago, ethanol was the darling of the alternative energy industry.
Mm-hmm.
Now, not so much, because it's driven up the price of beef, and it's, the nitrogen that's created has caused pollution issues and so forth. I'm wondering, do you have any thoughts about the future of ethanol?
Yeah, I mean, I didn't quite frankly think it was going to last as long as it did. And part of the reason it has is some of the replacements of the cellulosic products have been slow. The technology hasn't developed as fast. But, I mean, we've seen it. We have an ethanol plant south of Albany, down in Pelham. It was, I think, a little late in the cycle compared to the big plants in the Midwest. And it was built with all the modern bells and whistles. And then what happened was the price of corn went to $8 a bushel. It went through Chapter 11, came out. Now it's being helped by the fact that corn is down 354, it's 4 now. But at the same time, gasoline prices are down. Ethanol only does really well when you've got high gasoline prices and low corn. But I think the period of time when corn prices were up was in part because of ethanol. 40% of the U.S. corn crop was going to ethanol. And if you were a livestock producer who needed corn or corn substitutes, that raised the price of feeding your cattle, your chickens, your pigs up to very high levels. So the major opponents of ethanol have been the livestock industry within agriculture. Now, when ethanol started, corn was at $2 a bushel. You couldn't give it away in a sense. And it made, I think, about cents. But my guess is that ethanol will hang on for another 5-10 years, and something new is going to come along, and those field crops will go back to something else. Although there are other issues, they're talking about switchgrass and other vegetation. But that raises some interesting questions, because to grow that stuff, that's going to have to replace existing commodities. So there may be an effect there. Renewable fuels are touted, trees and everything else, because after you burn them, after they do emit carbon, then you grow them up again and they suck it out. Well, that's only true to the extent one is growing as much as one is consuming. When you throw agriculture into that analysis, I'm not sure where you come out. I mean, what are you all hearing on that? This has got to be something you hear talk about.
We're watching it. Of course, natural gas is the same as an alternative fuel to coal for produce electricity, and what goes up and what goes down at the same time. For instance, natural gas as a transportation fuel is only attractive when diesel fuel hits about $2.85 or so per gallon. Only then does it make sense to switch. So our customers are asking the same thing their customers are. When does it make sense to switch?
Yeah, and now I must say, for my farm clients, when they could take a load of corn down to the ethanol plant without a contract, get $8.30 a bushel, it was wonderful for their economy. But most of them were livestock producers. And that's ultimately our challenge. We tend to go back and forth. Ultimately, we're going to hit a wall. And what the right combination is to get over the wall is going to be the challenge. Again, any more questions? Otherwise, I appreciate you having me here. Yes, sir.
got 1,000 acres, and I need to make base reallocations.
Ah. Yeah, you do.
Yeah.
Oh, but this is what I've done for the last 2 months. I've worked every weekend trying to capture these payments and deal with these issues, so we could do one more.
What are you suggesting you apply to do marginal areas like or in Mark versus a PLC? I've run every analysis.
Well, see, this is really dangerous. I probably can't speak about Kentucky. Okay, our situation in Georgia is so different. We have cotton-based that became generic-based, a very high peanut reference price. So farmers who were under 1 payment limit for years now need 2. And the base reallocation issue there is simple. If it gives you more peanut base, take it. If it doesn't, don't. What base do you have now?
1,000 acres with 80 acres.
And what,
Was patch.
and what were you growing on for the last 4 years?
I bought horse farms, ripped out horse fence, and raised corn.
Okay. You raise corn? So, I mean, your conversion, whatever your base started at, chances are you're going to want to allocate because you're going to get mainly corn base. And in Georgia, I was trying to do the calculations of what the ARC county average program was going to pay on corn. We got a fair amount of corn and corn base there. I decided that at least this year in 15 probably, ARC county average was the way to go. It's going to pay about 70 bushels, $70 a base acre. And when I read all through the Midwest, that seems to be the choice. Now, PLC on corn, if you elect it, that's probably going to be very small. It's a crapshoot, but most of my clients are going ARC county average on corn and most of the Midwest, so probably the group think is as good as any. And since you're growing corn anyway, at least you're going to have a base that corresponds with your production and ARC county average. I mean, $70 is better than a kick in the butt. Of course, that's based on what your county yields are and the spread between a 5-year county year average and the current crop year. If you're interested in doing the calculations, go to the Farm Service Agency website, click on PLC ARC. On the left, there are a bunch of Excel spreadsheets that will give you the average county yields by crop for every county in the country. And then if you really want to do it, there's some 3 different spreadsheet programs developed by different universities. I'd go to the one for the University of Illinois probably and run your numbers through that and see what it comes out with. And if my recommendation is wrong, don't call me.
There's actually going to be a quiz on that last question and response now. If everyone's
Thanks for spending the afternoon with us. Safe travels.
Wow.